Good morning, Ms. Hofmeyr. Good morning, everybody.
Good morning, Chair.
Are you ready to proceed?
We are indeed.
Thank you. You may.
Thank you, Chair. Mr. Bester and the Chair, if I could ask you to take out Exhibit U4 File 4, which is where we completed the testimony yesterday, and the relevant page is page 810. Mr. Bester, you'll recall that this was the letter dated the 24th of June 2015 that you wrote recording the material terms that the parties had agreed on at a meeting on the 19th of June 2015. Do you recall that?
Yes, I do recall that.
We were dealing with some of the provisions of this letter. The first of those, which is reflected at paragraph 1 on the page, is that the coal was going to be supplied from the colliery extension, and it was stipulated that it would have to comply with the full combustion test to be conducted on that coal. And we'd spoken previously in the evidence about the necessity for that provision because that coal had not yet been mined, nor had it been tested. Is that correct?
Correct.
We were then dealing with the second paragraph on that page. I'd like to just look at that. What is set out there is that the proposed volume is 200,000 tonnes per month from October 2015, subject to all the required ESKOM approvals, including a requirement for the volume at the relevant power station. Mr. Bester, as I recall your evidence yesterday, you placed some emphasis on that as a protection for ESKOM. Can you explain to us what you meant by that?
I can only try and think of what my reasoning was at the time, and as I tried to indicate yesterday, it may have been that this is a relatively new supplier. If it was to increase from 100,000 tonnes per month to 200,000 tonnes per month, it would move from being almost a 10% supplier to Mayuba Power Station to almost being a 20% supplier to Mayuba Power Station. So if this supplier was to fail and was not able to deliver, it would not be good for ESKOM, and it would be more difficult to replace. 100,000 tonnes is something that we can probably manage. 200,000 tonnes would be more problematic.
So as I read this, you're not committing to taking the additional tonnes. You're saying ESKOM will take it if there is a need for that volume at the power station. Is that a correct reading?
I agree with that, yes.
Right. And then in the third paragraph on that page, you stipulate that all contract conditions and subsequent modifications as per the current contract remain. And you go on to say, further to the above, it's important to note that the record of discussions on the above-mentioned material terms are all subject to a duly signed modification to the current coal supply agreement between the parties and compliance with the following. And then you stipulate a series of further conditions that we referred to yesterday. What I'd like to focus on here is your insistence at this part of the letter that there be a duly signed modification to the existing coal supply agreement. I want to suggest to you that that's yet another protection for ESKOM in relation to this engagement. Would you agree with that?
Yes, I would agree with that, but in hindsight now, it wouldn't have been proper to have signed an amendment to the original agreement on this basis. If you recall, it would have been outside of mandate to modify an existing contract to essentially double the volume on that. I think it would have been incorrect to have signed an amendment. I may have erroneously worded it that way, but it would have been incorrect, but there was an attempt to protect ESKOM's interests.
Okay, let's just pause on that for a moment. If it was outside the terms of the medium-term mandate,
yeah,
why is any agreement being forged at all with Tegeta?
As I indicated yesterday, I penned this letter to acknowledge more than, it's not a contract, so in my mind, it was really to acknowledge the letter and the discussions that had, as I said, probably been had with Ayanda and the letter that had been received.
Mr. Bester, we dealt with the point yesterday that this letter was only an acknowledgement.
Yes.
And I put to you in the course of our discussion that at least the language of the letter does not convey that. Do you accept that?
I accept that may be the case, yes.
Are you aware that ESKOM regarded this as an agreement between itself and Tegeta?
I was not aware of that, but you subsequently informed me that ESKOM used this in 2016, I think, to attempt to approach National Treasury.
Correct. We'll come to that. I'd like to then go to what happens with this letter, if I may. And Chair, this is the aspect of the Brockfontein evidence that has been derived from the hard drive data that the Commission procured and had recovered overseas. You heard about that in the application to receive that. So this is not aspects of the hard drive data that we understand has previously been disclosed in the public domain. And for that purpose, we need to go to the previous page, page 809.
Right.
You'll see at page 809 that in the sort of middle of the page, there's a heading forwarded message. And it is an email from Ms. Nteta to Mr. Nath. Do you see that, Mr. Bester?
I do, yes.
And what it says is, "Good day, please find attached letter for your attention, regards." Now, that letter that we have just been looking at is the letter that was attached to the email as it was retrieved from the hard drive. And what I'd like to then focus on is the email that appears above that on the page. Mr. Bester, can you just indicate for us who is that from and to?
It appears to be from Mr. Ravindran Nath, and he sends it to Mr. Tony Gupta.
And can you tell us what time of the day that is on the 24th of June?
That appears to be 10 o'clock in the morning, I would guess.
Indeed. I think the precise time is 7 minutes past 10.
Yes.
And could you read for us the text of that email?
Dear Tony G., please find enclosed the letter from ESKOM and draft letter as discussed. Regards, Ravindra. I'm not sure why he would refer to it as a draft letter. It was signed.
Well, I can explain that to you in a moment, because what he's actually signaling is that there are two letters attached. If you look at the sentence, please find enclosed the letter from ESKOM, that's your letter.
Right.
And he's referring to a draft letter as discussed. So let's go to look at that draft letter. The draft letter, which is an attachment then to that email, you will find at page 812. Mr. Bester, this is a letter, draft letter, which, as I say, was attached to that email when it was recovered from the hard drive, that is entitled Coal Supply Offer, Tegeta Exploration and Resources, Brockfontein and Brockfontein Extension Collieries. Could you please then read the first sentence of that draft letter for us?
We refer to the above and wish to thank you for your offer to supply an additional 100,000 tonnes per month of coal from ESKOM.
To ESKOM, apologies.
Sorry, to ESKOM from your Brockfontein and Brockfontein Extension collieries.
With effect from the 1st of October 2015.
Correct.
Who is the purported author of that letter as you read it?
It should be from myself. As I said, Ayanda probably would have drafted this letter for me, and I would have applied my mind to it. And if I was comfortable with it, I would have set that out. I would not have been aware that she was being prompted from outside of ESKOM.
But this letter, as it is attached to Mr. Nath's email, is a draft of a letter that Mr. Nath prepared. isn't it?
Yes, I would guess that then it would have been him that drafted that. I would assume that, yes.
Right, but purporting to write what ESKOM should be saying to Tegeta.
Correct.
Is that a fair reading?
Yes.
Well, let's go over the page to see how that draft gets to ESKOM, and you'll find that at page 813. This is a further email recovered from the hard drive. Can you tell us who it is from and to?
It is from Ravindranath, and it's to Ayanda and Changa.
And at what time is it sent on Wednesday, the 24th of June?
20 past 10.
So just to get the timeline right, at 7 minutes past 10, Mr. Nath sends to Mr. Gupta the letter that he'd received via Ms. Nchanga from you, dated the 24th of June.
Yeah.
He forwards that to Mr. Gupta, together with a draft letter as discussed, quote. That is the draft that we've just looked at, which is the wording of a letter that Tegeta would like to receive from ESKOM. And I say that because in the email we're looking at the moment, 13 minutes later, Mr. Nath sends that draft letter to Ms. Nchanga. And if you could please read for us what is said in that email to Ms. Nchanga, who at that stage I understand was in fact Ms. Nteta, but that's a detail.
That's probably still her email address. Hello, madam. Thank you for the letter. However, from our bankers' purposes, we need letter on the enclosed lines. Kindly help in this regard.
And let's go over the page, that's 814. That's a replica of the draft email that we saw previously, is it not?
It appears to be exactly the same wording as as on page 812, yes.
Right, so 13 minutes after Mr. Nath forwards your letter and his draft to Mr. Gupta, Ms. Nchanga receives that draft. I'd like to look at what this draft changes about the position that was reflected in your letter of that same day. Let's look first at, you've read for us the first sentence, which is thanking Tegeta for their offer. The second sentence states the obvious, which is that this is going to increase the total supply to 200,000 tonnes per month. And then it goes on to use the wording of your previous letter. Following our meeting on the 19th of June 2015, ESKOM wishes to record some of the material terms the parties agreed on. And below that are the three aspects of the previous letter that you had written on the 24th, but with, I'm going to suggest, some material modifications. And I'm going to suggest to you, Mr. Bester, for your comment, that these modifications are ultimately to the detriment of ESKOM and to the benefit of Tegeta. So let's go through them. You'll recall that your letter of the 24th required any new coal supplied from the extension to be subjected to a successful combustion test. That paragraph has now been amended to read as follows: the additional coal supplied must comply with the relevant specifications contained in the current contract. I just need to pause there to engage with the Chair about a debate we had towards the end of yesterday, Chair. You'll recall that you made the point that we could understand the letter to indicate that the parties did not regard the omission of that double asterisk to have taken place pursuant to the May 2015 letter. And I'd indicated to you we'd see a response from Tegeta.
Yes.
That suggested otherwise.
Yes.
This, we submit, is that response.
Yes.
Because what is only stipulated here is that it must comply with the relevant specifications contained in the current contract, but if those two asterisks are gone in the current contract, and no reference is made here to the requirement for a successful combustion test, that has gone, has it not, Mr. Bester?
Absolutely, absolutely.
Let's go
Of course, you know, when we were looking at that letter of the 24th, it was on the assumption that it was accepted that it reflected, both parties accepted that it reflected their agreement. So there seems to be something subsequently, yeah.
Indeed, Chair.
Yes, yeah.
Let's see what happened with the volumes. You'll recall your letter of the 24th put in a key protection for ESKOM. and you've explained to the Chair this morning the rationale for it, which was that ESKOM wasn't to be obliged under the language of your letter to take additional tons. It was going to take them if it required them. But let's see how that changes under paragraph 2. Could you read for us what is stated there?
From their draft.
From their draft, yes.
Volumes. The proposed volume is 200,000 tons per month from 1 October 2015.
So what is missing from your previous letter is the further stipulation that ESKOM would take it if it needed it, correct?
Correct.
And then the contract conditions at 3 are a replica, as I have it, of what you'd stated. It reads, all conditions and subsequent modifications thereof as per current contract, with a fairly long number remains. But what it doesn't include is what you'd inserted thereafter, which was that requirement for a formal modification to the existing coal supply agreement in terms that satisfied the amendment requirements of that agreement. Do you accept that that has also gone?
I agree, yes, it's gone.
I'm sorry, I missed that last part which you say is gone. Just
Chair, let me go over it again. You will see if we just compare it to 810, which is Mr. Bester's letter of that date. Mm-hmm. Towards the bottom of the page,
yes,
there's that further stipulation, which is that further to the above, it is important to note that the record of discussions on the above-mentioned material terms are all subject to a duly signed modification of the current coal supply agreement between the parties. So I'm saying that has gone.
Yes.
There's no stipulated requirement now that we must do this all correctly and in accordance with the amendment requirements of the agreement. But
yes,
Chair, it goes further than that, because after that paragraph on Mr. Bester's letter of the 24th, there were further conditions stipulated.
Yes, 3 of them.
3 of them, none of those make an appearance in the redraft that is received from Tegeta.
Yes.
Mr. Bester, at this point, I'd just like to ask, is it customary for ESKOM to receive drafts of its letters from its suppliers?
Definitely not.
Had this ever happened before in your time at ESKOM?
No. The other thing that that is abnormal is if look, I would normally not be involved with the medium term at this level. I think another thing that probably would have happened under normal circumstances is that I probably would have used firm language, but be polite. I would have told the supplier to get lost in a polite way.
Well, let's just pause on that for a moment, if we may.
Yes.
Why did that not happen on this occasion?
Overnight I have reflected a lot on that, and I'm trying to think where I was, and I do recall, as I've tried to indicate, this is not something I should have been involved with at that level of detail. I should have been able to delegate to one of my delegates who should have had the best interests at heart. It's not evident whether, it was not evident at the time, and I cannot make any allegations that she was aware of that or was trying to mislead me, but it may be possible. It may be possible that because of the flow of information that I did start missing things because of the pressure. I would admit that I would indicate that the one thing that I am glad that still remained, and that maybe I insisted on that, is that the last line, but you may have a different interpretation, that it's still not a contractual commitment, and the way I used to protect myself from a contractual commitment, didn't always like to send letters to acknowledge this, because they sometimes have a perceived commitment. But you would then caveat it by saying that no liability is created here. But what was happening at the time, I was negotiating, as you will be aware, and I'm not sure if we'll have time to go into that. I was negotiating the Optimum contract. I was negotiating the Arnott extension. I was negotiating the empowerment of Anglo American's portfolio. I was negotiating the new Largo portfolio. I was dealing with the war room, and up to a year prior to that, I was reporting to Kiran Maharaj, and she was reporting before that time to Mr. Dan Marukani. And even Mr. Damas, I would talk to from time to time about things, and I trusted all three of those people. And if I had taken a strong stance with a supplier, they would have supported me if I had good reason to, and not accepted this kind of behavior. I had already been told by Mr. Mboweni twice that he would replace me. The one was specific to this negotiation, and the other one was related to another incident. I can't offhand remember what it was related to. And then I was also aware at the time, I had heard it from internal sources and from external sources that there were two people lined up to take my position, and that they were looking for someone to get rid of me. And I wasn't going to let something like this stand in the way of what was more important, in my mind, for ESKOM, those other significant contracts. So I probably would have signed it to get it out the way so I can carry on with my business, and I may not have applied my mind properly, but I still feel comfortable that it's not a contract and it was an acknowledgement. But yes, it certainly does remove some of those protections that I would normally have applied, specifically because we were dealing with these suppliers.
Mr. Bester, were you shown this draft that had been received from Tegeta at the time?
No. I would have been as gobsmacked as I am now. It's the first time I saw it when you showed it to me last week.
But then why did you reply the next day to change the letter in the precise terms that Tegeta wanted?
So, I'm sorry, I'm saying I don't think I would have seen the draft drafted by Mr. Nath.
I understand that,
but
your
draft,
letter
yes,
of the following day, which you'll find at page 816, gives Tegeta exactly what they wanted.
Yes.
So how does that occur?
I don't recall the specific instance, but I cannot deny that I signed it. It is my signature, and it probably is.
Well, maybe.
I beg your pardon.
Oh, just finish?
No, I do recall that there were one or two instances where I had clearly frustrated them, but I'm not sure if it was because I saw it in the Gupta leaks or someone had told me about that. But I cannot, I must admit, if I was to try and specifically say exactly why I signed the second letter, what the conversation was, what led to that, I can't recall.
Were you, during this period, being assisted by anybody in your team, or Ms. Ndeta, in the drafting of the letters that you were doing? You know, in other words, was there somebody doing a draft for you and bringing it to you, and you would look at it? If you are happy, sign, or if you are not happy, amend it or replace it altogether?
Correct, Chair, yes. Specifically in this, with the medium-term mandates, it would have been the norm that my direct reports would have written letters on my behalf. I didn't give them a full mandate to do that. Commercial letters I wanted to still be from my office, and my preference was that I would send it. And yes, I sometimes got the wording wrong. It appears as in a letter yesterday that it gives the impression that I was there, but we try to capture it always from my office, yes. So Ms. Ndeta would have drafted this. She may have been assisted from legal. I think at the time, the lady I referred to quite often yesterday as my legal counsel, I think she'd also resigned by then. So whether there was any legal assistance to Ayanda to write the letter, I cannot comment.
Then with special reference to the letter, your letter of the 19th of June, as well as that is the one at page 810 that we have dealt with, as well as the one at page 816, do you know whether Ms. Ndeta assisted you in any way by way of drafts or discussions with you as to what should go into those letters?
It is more than likely that she would have held the pen and I would have approved it, yes, or amended if I felt it needed to be amended.
Would she have brought to you a draft, or would you have drafted it and said to her, what's your input, and then she would bring it back to you, or how would this have happened?
She would normally draft it, and if it was acceptable, I would sign it straight away. And if not, I would use my red pen that I was famous for.
But you do you have any recollection, not as to what would have happened, but as to what actually happened in regard to the two letters, or do you have no recollection?
Chair, I do not recollect this instance.
Yes, but to get drafts from her was normal in regard to letters that were dealing with this topic.
Yes, Chair. My team would have done most of my drafting for me at that level.
Yeah, of course, one would have expected that if she brought you a draft that was significantly different from your letter of the 19th of June, the one at page 810.
Yes.
Subsequently, if she brought you something that was significantly different or that sought to amend that letter,
yes,
one would expect you to have raised the issue with her. Why are you changing this? And,
yes.
And do you remember whether you did ask her about that to the extent that she may have prepared a draft for you in regard to the letter at page 816?
Chair, I cannot honestly recollect that instance, and it would be, yes, it clearly would have been good to have been able to recollect it, yes. And clearly there should have been some discussion. I honestly cannot recollect.
Yes, but you can't remember any discussion.
Chair, no. It's about 4 years ago now.
Yes, no, that's fine. Do you think that there is a chance that you might have not applied your mind to this and signed without appreciating the difference between, or the effect of your letter of the 6th of at page 816 and your letter at page 810? Do you think you might not have applied your mind when there was such a big difference between the two and you signed, but maybe now you look back and say, I shouldn't have signed without interrogating this?
Chair, I think I'll always be reluctant to say I didn't apply my mind, but I cannot honestly reflect on that. I think it was too long ago. But as I try to indicate, I think in the frame of mind I was in at that time, I think I would have been frustrated, and I probably would have been wanting to deal with it as quickly and as efficiently as possible so that I could get on with what I perceived as more important work to be done. And the fact that that caveat was still included at the bottom, which says ESKOM shall bear no liability for any costs or liabilities incurred by the supplier on the basis of this letter. That may have given me sufficient comfort to sign the letter in any case, even though I wasn't happy, that it's not a contract. To my mind, it's not a contract. Whether it was used later pretending to be a contract, it's not a contract. I did not have the authority to sign and contractually agree. That delegation of authority sits with the divisional executive, not with me.
Well, I can certainly understand your taking the view that that last line provides protection, and it may well be that it does. But I wonder whether your inclusion of that provision in the letter, that part, the statement in the letter, may have come about because you could see that there could be problems with some of the things that were in the letter, and you just wanted to make sure that if there was trouble, ESKOM could rely on that, or you could rely on that to say, well, it wasn't something intended to give rise to any liabilities.
Chair, that was there was a line I think I used from previous correspondence. I had a couple of years earlier an instance where fortunately there was no paperwork, but because we'd been negotiating with the supplier, there was a perception created with the supplier, or an expectation, it's probably a better word, an expectation created with the supplier, because we had been negotiating with them for a number of months, and there was an expectation that we would conclude a contract by a certain time. And then we had a technical failure at one of our power stations. For example, maybe it was one of the Duva units, although that had a fixed supply. It may have been an instance like that where one of the units blew up and we didn't need coal. The coal supply plan changed. Until ESKOM has actually signed the agreement, there's no liability agreed. So having learned from that experience, every letter like this, that we had a potential concern there. So it almost tries to protect similarly to what the earlier letter did by saying that to the extent that ESKOM required the coal, this also tries to protect that should the situation change, should ESKOM not have money, should ESKOM not have a requirement, that there's still no liability created. This is not a contract.
Well, Ms. Hofmeyr may take the issue further, but nevertheless, what would remain troubling, irrespective of that statement, is simply that a situation existed where somebody from outside of ESKOM was a supplier or potential supplier was dictating to somebody at ESKOM to say, ESKOM must draft a letter along these lines to us. You know, that's worrying. Okay.
Absolutely unacceptable. Yes. Had I been aware of that,
yes.
I cannot think what my reaction would have been.
Yes. Thank you. Ms. Hofmeyr.
Thank you, Chair. Just one or two follow-up questions, Mr. Bester. What you've indicated to the Chair in your last answer was that what might explain your willingness to sign these letters was an endeavor to deal with this efficiently, get it out of the way. I recall you as saying it was something of an irritation. What I want to ask you in fairness is, wouldn't that most readily have been achieved by simply saying no thank you to this offer?
Yes.
And can I ask one other follow-up question? You've emphasized the role that last sentence on page 816 might have provided. Chair, just a point of clarification. Those two letters, 810 and 816, were
yes.
actually dated the 24th and the 25th of June. They're a day apart. They refer to the meeting of the 19th.
Yes,
but
yes.
that is not without significance, because it is a day later that the fundamental changes are made. So I just did want to clarify that.
No, that's important. Yeah.
But Mr. Bester, I understand your evidence to be you weren't shown the draft that came from Tegeta. But I would like to ask you for your comment on the reason that is given to Ms. Nchanga by Mr. Nath for these changes. Because you'll see that at page 813, it's the email that he sends to her. He says, thank you for the letter. That's the letter you wrote on the 24th with those key protections for ESKOM. And what he goes on to say is, however, from our bankers' purposes, we need letter on the enclosed lines. Why would Tegeta's bankers' purposes be relevant at all to ESKOM?
I think it's the same line he used a couple of months earlier.
Indeed, it does seem to be a trend.
Yeah.
And would you confirm and give the same answer as you gave previously, it wouldn't be of a concern to ESKOM?
Under normal circumstances, not. I cannot recall whether what the motivation I absolutely cannot recall the motivation Ayanda made to me in terms of changing that letter, whether she conveyed the same to me.
The reason why I wanted to emphasize that is, would you accept that the letter at 816 might be read by a banker, despite that last line, to be a commitment to ESKOM, which could then be a further source of funding to Tegeta?
Yes, it would be unfortunate if they brought a lender under that impression, yes. But yeah, I would hope that a smart banker would not lend unless they had a contract. But
for the last sentence of the first paragraph of the letter that they received from you on the 25th of June, which reads, following our meeting on the 19th of June 2015, ESKOM wishes to record some of the material terms the parties agreed on. Do you accept that that might be interpreted to then contain a recordal of the agreed terms?
Yes, but I do not wish to take liability for a decision a bank made based on that.
No, indeed. All I'm asking you at the moment is how it might be interpreted by the bank.
Correct.
Thank you.
Let's go back to the two letters, the one at page 810 and the other at page 816. But actually I want to focus on the letter at page 816 and the draft at page 814. We all accept, don't we, that if you look at the three items on the letter at page 816 under code specification, volumes, and contract conditions, except for that last statement that you have pointed out, except for that, we all accept that those were the terms requested in the draft at 814.
Yes, they appear to be the same. Chair, they also appear to be the same as the first letter I signed. So is it...
Sorry?
Chair, I do agree that that wording is very similar to the, or almost word for word the same as the letter signed on the 25th.
Yes.
But it also appears to be the same as most of the wording on the on the 24th.
Okay, no, that's fine. But we know what's different, isn't it? What's been omitted.
Yes.
Yeah. Now, if you look at what's been omitted on the draft letter at page 814, which is also omitted on the letter at page 816, would you not accept that the probabilities would be that in preparing your letter at page 816, you would only have written that letter omitting exactly what the draft at 814 wanted to be omitted if either Ms. Ndeta or somebody else had prepared the draft for you who was aware of the draft from Tegeta, or if you had seen the draft yourself. Otherwise, it would be inexplicable how you would make those omissions that are made at page 814 when in your letter of 24th you had written the letter the way you had. Would you accept that the probabilities would either be that somebody who was aware of this draft at 814 had prepared a draft for you or the draft for you?
Yes.
Or you had seen the draft at 814 yourself?
Yes, I would acknowledge that the drafting of this letter very much would reflect someone having seen, let's maybe refer to it as the draft on 814 that appears to have been drafted by Ravindra Nath. It appears to be the basis on which the ESKOM letter was prepared. The choice of language and the order of the bullet points, etc., all they're too close to be coincidence.
Okay, thank you.
Thank you, Chair. Mr. Bester, that concludes the aspects in relation to your involvement on the Brackfontein contract. There are two further items I propose to address with you in your evidence. The first is simply to deal with certain findings that were made against you in the Fundudzi report, because in fairness to you, I'd like to put those to you for your comment. And then, Chair, the second aspect, which I neglected to recall yesterday when we were thinking about the timing this morning, there's an aspect of Mr. Bester's statement that deals with the Optimum negotiations prior to the fourth addendum, which are important, and I propose to deal with those briefly thereafter.
That's fine.
Mr. Bester, you will find the Fundudzi report in Exhibit U4, File 5. what I'm going to propose in the interests of time, and with your leave, Chair, is that I provide the references, but it's not essential to go to the actual pages.
Okay, that's
I will
fine.
simply summarize what those findings are and then ask for Mr. Bester's comment. But
That's fine.
Mr. Bester, if you at any point would like me to give you the page and to turn it up, please feel free to tell me that. Mr. Bester, the Fundudzi report, as I read it, makes 3 findings against you. The first of those is that your conduct in relation to the Brockfontein coal supply agreement was irregular because you allowed Tegeta to dictate the terms of the coal supply agreement to the benefit of Tegeta and to the detriment of ESKOM. Just for your reference, Chair and Mr. Bester, you'll find that in that file 5 at 1187, paragraph 6.13.12.23. But I can content you that that is a fairly verbatim recordal of what is said there. Do you have a response to that, Mr. Bester?
Yes, if I only respond to that point, I can say that in my own mind, I did everything in what I perceive in my power to put everything in place to, number one, initially prevent the contract from even starting negotiations with our team. Well, not the contract, but the supplier, and then later on to try and put all the provisions that ESKOM required to protect itself in there. I may have, in the course of time, with a constant pushing and as reflected in the last 2 letters, it may appear as if I went soft on them. Yes, but it was not the intention to give them what they wanted.
I'll come back to that in a moment. I would, in fairness to you, also like to just follow up a few other aspects of what we will submit in due course your evidence has presented in order to give you an opportunity to comment on those. As we read your evidence, Mr. Bester, what it does show is that Tegeta secured a 10-year coal supply agreement in a situation in which, on your evidence, a 5-year agreement with an option for another 5 years would have been in the interest of ESKOM. Do you accept that?
It would have been a better situation for ESKOM, yes.
Thank you. The second is that Tegeta was allowed to proceed with a contract despite a critical condition precedent that would have, which the non-satisfaction of which would have resulted in no agreement coming to be operative, nonetheless continuing. Do you accept that?
I do.
And do you accept that Tegeta received the benefit of no one following up on that condition precedent?
Yes, I do agree on that.
And then the third is that Tegeta managed to dictate the terms of a further extension of the agreement on terms that were favorable to its bankers and less favorable to ESKOM.
Yes.
Thank you. Mr. Bester, the second finding that was made against you in the Fundudzi report, I hesitate to call it a finding because it's actually just a speculation on the part of the author of the Fundudzi report, is that you may have received gratification for changing the conditions of the coal supply agreement. Could we please have your response to that?
No, and I think if I had, why would I have resigned from ESKOM? I think I would have been in a good place. So the answer is no.
Thank you. And then the third is that you breached Section 34 of the Prevention of Corruption Act by not reporting the corruption that was evident to have occurred in this contract. What is your comment on that?
My comment is that, in my mind, the contract, the contract in itself was not, I'm not sure the word you used, was not fraudulent or
corrupt. Do you continue to hold that view now, given everything that has been presented in the evidence at this commission about that contract?
I continue to hold the view that my intention was not corrupt, and I may have not followed up on that specific conditions, but there were processes in place that should have ensured that happened. Yes, and then in particular, what should have happened is that if that contract had been managed, and you've been through that in the previous few days, had that contract been managed as it was signed, bar the provision that the burn test hadn't been done for the blend, the coal qualities and the price and the delivery mechanisms, everything else, had that been contractually performed on, there should not have been any reason for fraud to be committed, or one cannot conclude that there was fraud committed.
If it had been implemented in accordance with its terms.
Yes.
Thank you, Chair. I propose to move to the optimum aspects unless there are further issues.
Before you do that, is it possible, or how possible is it, Mr. Bester, that in regard to that letter of the at page 816 that we looked at earlier, what are the probabilities that at that stage, with the threats to your job that you told me about, and everything that was happening at the time around this issue and other issues, what are the probabilities that you may have reached a point where you wanted these people to, so to speak, leave you alone, but you wanted to make sure that by putting that statement that there would, as far as you were concerned, be no liability for ESKOM, but maybe they would think that they've got what they wanted?
I'm not sure I understand the question 100%. Yes, it was the intention. In hindsight, I may have been overthought my own ability to outplay or outmaneuver. It was my intention not to aggravate the situation. I was concerned about obviously losing my job. I was relatively comfortable that I would find employment fairly quickly after that. So it wasn't employment that I was worried about. I actually, whether you believe it or not, I did feel that I had far more important things to do, and it was a sad day for me. Sorry, I need to compose myself.
Okay, no, that's fine. If you want us to take 5 minutes, we can take 5 minutes.
No, it's fine. I'd rather continue, Chair. There still is a lot to be done. I dedicated my 5 years to ESKOM, and I've sacrificed. And okay, let's take 5 minutes.
Well, I'll take 5 minutes. We'll take 5 minutes. We'll take 5 minutes. Let's adjourn for 5 minutes.
All right.
Mr. Bester, how are you feeling?
I think I've composed myself, Chair. Thank you.
Okay. I just want to say this to you, and I may have said it yesterday already. I am interested in knowing and hearing about whatever pain people may have suffered as a result of conduct that may be part of state capture, may be part of corruption in general, in government departments, in parastatals. I do want to hear about that because that's important. And I think the nation needs to know what suffering people may have gone through as a result of these things. So I just want you to know that I am interested in you sharing that with the Commission if you are able to.
Yes, thank you, Chair.
Thank you.
So even though I had been at ESKOM probably not as long as some of the colleagues I'd referred to, such as Mrs. Maharaj and Mr. Brian Damas, Mr. Dan Marikani, who I reported to, who initially appointed me, he was also only there for a relatively short period. But these are people that I could look up to, that I could trust, and that supported me when I wanted to do things like renegotiate the Optimum contract, when I wanted to renegotiate the Medupi contract with Exaro, when they'd been removed or left. I definitely didn't have someone in Mr. Mboweni that I could confide in. He didn't give me guidance. He wouldn't give me guidance, and I couldn't. It was clear that I couldn't trust him. I knew I couldn't trust Mr. Koko. He was Mr. Mboweni's direct report, and it was clear that that Ayanda was being influenced and put pressure on from the executive going over me. It was clear that they wanted to replace me. I think at the time I had a massive workload, but I was prepared to shoulder that. Even the position I have now, the company approached me 2 years prior to that. I was always comfortable that I had somewhere to go, but I was more passionate, and I think I picked up some of that passion from some of the good colleagues at ESKOM. Sorry, it's just a tragedy what happened to some of the people. So, yeah, as I said, there came a point. Then I think the last straw came when I still thought I could maybe make a difference. I could
drink some water as well. Yeah.
I thought I could still make a difference, and there's a lot of important work, and there is a train coming. I mean, when I left, ESKOM had 10 long-term supply contracts, 20 short-term supply contracts. That's enough work for anybody in a day. A lot of the, you may be aware, and some people have told you, and Mr. Efron even spoke a little bit about that, the tied collieries, those collieries where the coal comes across the conveyor belts, especially the cost-plus mines, they're important for ESKOM's bottom line. That coal tends to be the cheapest coal. When ESKOM doesn't continue investing in those contracts, and there was ever since I joined ESKOM, the 2 power stations that were being built and the Ngula pump storage scheme, every single bit of money, this is my perception, the accountants at ESKOM may say I'm a little bit wrong here, is my perception that all the cash that ESKOM had went on those 3 projects. We were always told to make do at the cost-plus mines. Those volumes kept dropping, and I kept having to replace them from short-term contracts. Those short-term contracts come at a higher price, number one, and the delivery cost adds another 30% onto that cost. So you are not doing what you should be doing for ESKOM. About a year before I resigned, I think it was towards the end of 2014, I wrote a paper to the board after having got several things in place supported by my team, supported by finance, supported by coal planning, and a number of other clever guys in the primary energy department. We wrote a report that we wanted to table to the board that if ESKOM didn't spend 25 billion over the next 5 years at the cost-plus mines, that the cost of not doing that would be 92 billion. Mr. Mboweni signed that report, but Mr. Koko refused to sign that. It never reached the board. So those are the kind of things that started frustrating me. As you heard by Dan Mashiga's accounts, ESKOM now has 40 medium-term supply contracts. And to my knowledge, when I left, ESKOM was receiving about 20% of its coal from medium-term contracts, in other words, delivered by road or rail. It's now receiving 40% of its coal on road or rail, and that adds an immense cost burden to ESKOM. So I wasn't really that much, in all honesty, I wasn't really that much worried about my job. I wanted to get the job done. And this Brakfontein contract was actually just a frustration for me. And I wanted to deal with it as efficiently and effectively as I could without jeopardizing my position, because they would quite easily replace me with somebody else that would not, I would maintain, that would not have his eye on the ball, would potentially just be there at the behest of outside parties and not be focused on achieving the long-term strategy that ESKOM still needs to actually implement to this day. Thank you.
Thank you.
Mr. Bester, thank you for that. I'd like to move to your involvement in the Optimum negotiations. You will find that in your statement in Exhibit U4, File 3, and if you turn to page 16, 1/6 of that file, you'll see where that discussion starts at paragraph 38. Chair, we are in file 3 at page 16, 1/6.
Okay, thank you.
That is in Mr. Bester's statement, and we pick it up at paragraph 38, because that, as I have it, is where you commence your discussion of your involvement in the Optimum negotiations. Mr. Bester, I'd like to turn over the page and just start at paragraph 40, because you give some introductory background. But what I'd like to understand from you is your view in the course of these negotiations of ESKOM's responsibility to ensure the sustainability of mines like Optimum, as you've just described, which were built adjacent to power stations, and as a consequence of which could feed coal to power stations without the additional attendant costs of road and rail transport. Could you please just indicate to the Chair what role that sustainability played in your approach to these negotiations?
Chair, I think until I arrived at ESKOM, there was with many suppliers, there was almost like a them and us relationship. It was quite acrimonious at times, I felt, when I arrived there, and I felt it didn't help always fighting with your supplier. There were always these penalties, and yes, but they are there. You have to administer the contract. You have to keep your supplier honest, otherwise they will take advantage of that. But this was a particular problem. It is clear to me, and anybody looking at the facts, that the contract had good intentions initially, and I don't want to go into all the detail that Mr. Clinton went into, but the international coal price had dropped, I think, to about $75 a ton. The long-term average for coal is about $95 a ton, so then all exporters are making good money. When it drops to about $75 a ton, they're making money, but they're not necessarily happy shareholders. It was at this point that Mr. Efron started making noises about being unhappy with his contract, because at those prices and the way the contract was structured, it was exporting and it was supplying ESKOM. So the price to ESKOM was one of the lowest price contracts to ESKOM. It was not the lowest, but it was one of the lowest price contracts. And from my knowledge, from what costs should be from an underground section, from a large mine like that, they were a little bit higher than I anticipated from the studies that were done subsequently. It didn't surprise me that Optimum were talking about declaring a hardship, that the initial intent of the contract was not at that stage being fulfilled, if I can put it that way. Then the coal price dropped even further. It actually, I think, went close to $53 a ton on an export basis. To such a point that even Glencore stopped, or Optimum stopped exporting. It didn't even make sense for them to export coal. Then there was no cross-subsidy obviously happening, so they couldn't cross-subsidize the cost of supplying ESKOM's coal. There is one other, in fact, there were two others. I'm aware of one other mine where that is happening, where the coal is actually being supplied to ESKOM at lower than the cost to produce it. So this particular mine, though, is not part of a bigger company. So to sustain losses, although Glencore was the major shareholder, it had other shareholders, and it stands to reason that that a company like that would eventually declare itself bankrupt. So I wasn't surprised when Mr. Efron told me that they would eventually, I think that it's not far from bankruptcy, but would go into business rescue. So I think it was important for me before it got to that stage, and so what had happened is already Optimum had said, or Mr. Efron had said, that they wanted to start that arbitration process, which I think was discussed. The arbitration process would take a long time. Something like as complex as this contract, it could take the better part of a year, at least 6 months, and it would take the same resources out of my department and out of the primary energy department, legal, etc., and cost, as it would be to accept that there was a problem and to try and renegotiate a new contract. I had another objective. This contract would expire. It's not like some of the other contracts where ESKOM had an option, etc. This contract would expire December 31, 2018. So its last day was 31 December 2018. But yet the power station's life was would start shutting down from 2023 to 2025, if I remember correctly, but in that time frame. So I said to myself, and I probably engaged with Mrs. Maharaj as well. She was still there when I initially wanted to approach Optimum. I said to her, look, if I was Glencore or Optimum and we forced them to carry on supplying at 150 Rand a ton, we can guess what's going to happen on the 31st of December 2018. They will tell us they're no longer supplying us, they're no longer interested in supplying us, or the alternative was they would dictate the price at which so if we waited till that point, we would have no negotiating leverage. They would be quite happy to charge us 600 Rand a ton or 900 Rand a ton, whatever it felt like. And if the relationship was really acrimonious, they might refuse to supply us coal. So let's use this position. Let's say we'll come to some sort of a middle ground. I think that's maybe enough.
Thank you. Just a few follow-up questions. You've indicated that at the time that these negotiations were embarked upon, they were being paid effectively 150 Rand per ton. That was pursuant to the long-standing coal supply agreement. Is that correct?
Yes.
Thereabouts. I think you recorded as 154 Rand in your statement. The other fact I just want to get your comment on is at paragraph 40 at page 17. Because there you say in the second line, it was clearly not sustainable if Optimum continued to lose 60 million to 100 million Rand per month. Am I to understand that as being the consequence of being kept at the price of 154 Rand per ton?
Yes, and I use that range because that's what was verbally conveyed to me by Mr. Efron, and we subsequently obviously checked those numbers.
Indeed. But that's the background as I have it,
yes,
to why you wanted to take this longer-term approach to the negotiation, not allow it simply to come to an end at the end of 2018,
yes,
and propose a price that, as I read your statement, you regarded as fair to ensure the sustainability of the mine and to secure an important resource of coal to the power plant. Is that an accurate summary?
Correct, and the word fair I need to clarify. So the one thing principle I made very clear to Mr. Efron and to Optimum is that whatever price we agreed on, there would be no margin. It's not our problem that they bought the mine 2 or 3 years earlier, that they didn't do their due diligence properly, that they didn't forecast the market properly. It's not ESKOM's problem. However, we wanted to make sure that the mine kept its doors open or its gates open. So when we did our due diligence on what their costs were, it would be merely to cover their cost. They had a contract miner in there, and there was obviously operating cost, and there may have been some debt, but there was no, ESKOM would not pay a margin. As I mentioned yesterday, it was fair for us to pay you your cost plus a margin. This was not going to be that case.
And as I have it, you proposed, after detailed investigations with your team, a new price of 442 Rand per ton. Is that correct?
Yes, it was really not much of a proposal. I think we both knew that number and we both agreed that number. The financial model actually gave us that number.
And just explain to the Chair, if you will, how you justified, when you sought to make this proposal to the executives of ESKOM, how did you justify an increase of 154 Rand to 442 Rand for this coal source?
Yeah. So obviously the next answer would have come from any executive, even at an executive level, even from my very next superior, would be what are your alternatives? And because we obviously procure coal, and there was one other supplier already that was supplying, and Dan Mashika mentioned that name a couple of days ago. Lyceth was already supplying some volumes too. So it's possible to supply some of the volume on road. So we did quite an extensive study, obviously not done by myself, but it was done by my colleagues. And as I mentioned, we had quite a good database, and we had a pretty good idea where we could get coal. We did engage actually with potential suppliers. And we modeled that. So there were a number of suppliers we could get coal from, but we wouldn't be able to get the volume from. And the price was going to be relatively similar. Some of the prices that were lower, we wouldn't get the volume from, and some of the more expensive suppliers, none of them would be able to reach the volume. But there was a second, probably bigger problem there. And that is the practicality of actually delivering into the Indrina power station. This power station was built next to a mine that was supposed to supply it across a conveyor belt. So the stockyard is not designed to take its full volume in by truck. When a truck goes into a stockyard, it's got to drive somewhere, it's got to tip its load over, it's got to go over a weighbridge. You can't, depending on the size of the stockyard, you can't allow more than 2 or 3 trucks on that stockyard if it's very small, because you get a traffic jam, as simple as that. The road infrastructure around Indrina town was also not conducive for road trucking. One of the things, I've got to be careful I don't get emotional here again, because one of the things that putting more trucks on the road, it does result in, statistically, there is a loss of life. I think on average when I was at ESKOM, there were at least 6 to 12 fatalities per annum as a result of the trucks on the road. I'm not sure what the situation is now. Putting more trucks on the road is something that you should avoid, even at all costs.
The fatalities, how were they connected with the trucks on the road? Was it drivers or people who were workers who were on the trucks, or was it pedestrians, or how did they come about?
It's most often it would be other road users that would be affected by ESKOM's coal trucking. In my term, there were 2 instances where school children were killed.
Yeah. Okay.
Mr. Bester, you've indicated that there were a series of factors you took into account in order to justify this increased amount. And as I understand your evidence, you used a comparator. Well, if we're not going to get it from Optimum, what are the likely costs if we bring it in from outside? And what I understand you to have traversed now is some of the implications of bringing it in from outside with a power plant that's not designed to receive coal other than by way of conveyor belt. Is that correct?
Correct. The cost would have been fairly similar at best, if not more, and there would have been other knock-on effects which you can't price in, the loss of life and the logistics nightmare.
So as I understand your statement, you then did this work, arrived at a figure of 442 Rand per tonne, and you justified it with reference to this comparison. Well, if we're not going to take it from Optimum, what are we likely to get it at from other suppliers? Is that correct?
Yes, and I think it's maybe important to note at that stage there was distrust between the parties. Maybe just to give more confidence around the figure, the mine had been exporting as well, and it had been supplying ESKOM, and it's very important there to have separated those costs. And for a long time, one of the reasons it took so long is we struggled to get information. Not an unwillingness necessarily from Optimum, but an ability to distinguish what are ESKOM costs and what are Optimum's costs. And I think they stopped supplying the export market around about November. So within a couple of months, the audit firm it wasn't an audit firm, we appointed Basis Points Capital. It's a relatively small consultancy, and then we also appointed Nedbank to assist us with that. Just to, it was to give our executives the comfort that it had been done by reputable parties. So we were relatively comfortable that that was the actual cost that Optimum was incurring, and that they were not making any margin. I think a lot of people were hoping that there would be a golden wand that we would wave, and that there would be some magic fix, there would be some better option. But I'd been busy with this for a year and a half, and there was really no other solution.
And as I understand your statement, you then presented this to the executive of ESKOM. And can you tell us about that engagement?
Yeah, so there are a couple of steps. I think it would have been an EXCO, and then it goes to a board level, as most large companies would. But even larger companies you don't go straight to the full board, you go to a board tender committee. So something like that would normally have been able to be approved by the board tender committee. I may have mentioned in my statement, I wasn't surprised that the board tender committee didn't approve it. They did not approve it, but they felt that they wanted the full board to be appraised, or the full board to make a decision on that matter, which also didn't surprise me.
If you turn to page 20 of your statement, the first paragraph on that page actually begins over the page. It's paragraph 46. But what I'm interested in that paragraph is the sentence towards the end of the first paragraph, which reads, "I pleaded with my leadership not to allow a 15 million ton per annum mine shut down, one of the largest in the country, probably in the top 5 biggest coal mines in the continent." What gave rise to your need to plead with your leadership about this aspect?
I would have to reflect on the exact timing of that, but I think it was at the time when Mr. Molefe had just joined ESKOM, and the report had just been, he had just withdrawn the report from the board agenda, and so it may have been the day after, or he may have asked me to brief him. I can't reflect exactly on the date, but I remember my reference to that. I remember being in Mr. Brian Molefe's office with Mr. Vusi Mboweni, and there was one other gentleman that I didn't interact with that much, but I think he was in the office of the CEO. I really went through this full argument with those gentlemen again, and I really tried to convey to them that there was really no other option, and how important this mine is. At the time, I wasn't seeing, and you may be fully aware that there is not that much investment happening in the mining industry in South Africa as we would like there to be. Especially in the coal industry, a number of suppliers or mining companies were holding back. They were waiting to see how the new regulations would pan out. The coal prices, the export coal prices were also low. So it was not likely that we would see anybody ever opening at that point in time. It's not likely that somebody's ever going to open another 15 million ton per annum operation. Nothing that size. I think it's got 5 drag lines. It's one of the, it used to be one of the top performers. They're in an area where their geological conditions are different. They are one of the closest mines to Richards Bay, so they have a cost advantage there. So whoever owns the asset, provided they can mine that resource efficiently, the coal resource isn't as great, as I said, as it used to be, but it was a fantastic mine. The other consideration I had, which in hindsight I should not have conveyed, and I don't really recall if I conveyed it at that meeting or whether it was subsequently in the private meeting with Mr. Koko, where I conveyed to them that we were having problems, and as I said, it may have been to Mr. Koko. My memories may be a little bit vague on this. I'd have to refer to the affidavit, but I think I also conveyed that the mine is one of the closest other resources we have to Arnold Power Station. Arnold Power Station would also be struggling with its own supply over the next couple of years. I was trying to renegotiate a new contract with Arnold as well from the open cost section. And that it would be effective to supply it from there. So instead of letting the mine shut down, instead of forcing it to shut down, it would end up in somebody else's hands, and we would negotiate from a zero base, and they would dictate the terms. If they really didn't want to reach an agreement with Glencore, then let's buy the mine. You've heard big numbers, Chair, for ESKOM to buy a mine, pay 2.5 billion, whatever the figure is we would have come up with. For ESKOM to spend 2.5 billion to secure its supply would not have been a bad judgment call either, in my mind.
And what was Mr. Molefe's response to this argument that you presented to him about continuing with Optimum at a more reasonable price? I have to refer to that, but I think I remember the one thing he did say is, we'll build a railway line, and I said to him, it doesn't make sense to me. By the time you finish building that, the power station will be in its shutdown years. Just take us through that. I know these facts are well known to you, but did Mr. Molefe agree with you that you should enter into negotiations for a longer term contract at 442 Rand a ton?
Look, the negotiations were concluded, so no, he was clear that he did not want to agree to that.
And how did the railway line come up in that discussion?
So I said to him we had no alternative, and I think it was at the point when I explained to him it doesn't matter, even if he wanted Plan B, even if he wanted me to go and buy the coal for ESKOM, from medium-term suppliers. If I managed to get 10 different suppliers I'm guessing at what the figure would be. It would be maybe something like 800,000 trucks delivering there every day. I told him it's physically impossible. I myself do admit I've never been to the mine, but I rely on my technical colleagues. They told me the stockyard is too small. There's a subway that you need to drive through. There's a particular point in accessing the power station where only one truck can pass that section of road at one time. So that's a congestion point. There were a number of points that, so it's the size of the stockyard, the road infrastructure around Indrina town, that would prevent you actually from practically delivering the full power station burn on road. And then he said, well, we'll build a railway line. And I said to him, Mr. Molefe, with all due respect, by the time we've got the EIA approved and the railway line built, the power station will be in its shutdown years, which would be 2023 to 2025, in my memory.
Mr. Bester says...
sorry. That engagement that you had with Mr. Molefe on this issue, was it an engagement which you felt was on the part of both of you, in terms of which way both of you were looking at genuinely trying to find a solution to the issue? In terms of you raised arguments supporting your view, he dealt with them in a rational way. You might have disagreed with him, but he was putting across rational arguments based on somebody who was genuinely looking at trying to find a solution, or is it something that you can't tell, you couldn't tell?
Maybe I should mention one other aspect. As I said, Mr. Mboweni was there as well, and everything Mr. Molefe said he agreed with wholeheartedly. And I was the only one arguing the other point. Strangely enough, even though Mr. Mboweni had supported my document to the board, it was as if he was not going to challenge Mr. Molefe. But to get back to your question, Chair, it's maybe not fair. But to my mind, the options, there weren't many, the options that Mr. Molefe had put to me weren't thought through, to my mind. They were very quick responses to everything I said. They weren't considered.
Yes, but that's how far you can go in terms of describing his approach or attitude to the issue. That's how far you can go. You can't go beyond that.
Yes, it would be difficult to speculate further.
Yeah,
yes.
Okay, no, that's fine, thank you.
You go on in your statement to record the response from Glencore, or let me be specific, from Optimum, to the rejection of the fourth addendum. As I have it, that was to counteroffer to supply the coal at 300 Rand per tonne. Is that correct?
Yes, that's correct.
We have gone through some of that evidence with Mr. Optimum, and the documents attached to your affidavit on the score are actually also annexes to his statement, so I don't propose to go through them again. What I'm interested in was the interaction that you had with Mr. Molefe after that counteroffer was received from Optimum. You'll find that at page 20 of your affidavit, at paragraph 47. What was Mr. Molefe's response to that counteroffer?
I think the first part doesn't deal with the counteroffer. Yeah, so the first part, I mean, it was fairly public, and then but maybe I just summarize. So there was a counteroffer, and it was copied to me. So I drafted a response. I would be the one who would draft a response in any event. So I'm trying to think what the date was.
Well, I can give you the reference. The counteroffer appears at page 110 of that file, and you'll see that it's the letter from Optimum Coal Mine dated the 30th of June 2015.
Okay, if it was June, then I still would have been quite busy. But that's the only thing I'm trying to reflect on. So I drafted two letters. One was an outright rejection, one was an acceptance. And I took it to Mr. Mboweni's office for him to take to see if Mr. Molefe was happy with the drafting. Because at that stage, the other thing that happened with Mr. Molefe acting in that way, he basically took the negotiations out of my hands. And that's also the other abnormality. When he'd elevated the negotiations to his level, well, maybe if you have a big problem like this, it should be. So those letters all would have had to go from, it was just customary to go from his office. So I drafted those letters, and Mr. Mboweni, I think it was Mr. Mboweni, told me that I shouldn't even acknowledge the letter.
You shouldn't acknowledge it at all?
At all, yes. I think that's what my paragraph says.
Indeed,
yeah.
Indeed. Your draft, just for your reference, is at page 114.
I only found the one, yes. I didn't find the other one.
But are we to understand that those drafts were rejected and you were told not to communicate in relation to the counteroffer?
Yes, so my understanding is at the time there was no There was no correspondence on that. There may have been a meeting afterwards, which I've heard about subsequently.
What did you make of the counteroffer? Would you have accepted it?
Yes.
It was 140 odd rand less than what you were proposing ESKOM should pay, wasn't it?
Yeah. Look, we would have had to do some calculations, so maybe it's not that relevant. The one thing I had included in our negotiations is that post-2018, I still reserved the right for ESKOM to go out on tender and to try and find its own alternative coal. And if I reflect correctly on the letter, without going to it now specifically, I think what Optimum had done there, they had reserved a price to supply post that period. So they almost did build in a little bit of a clawback. And I can't remember now, not having looked at the letter recently, whether they had the right to or whether there was a commitment.
Well, we did go through it with Mr. Optimum, but it is a point of some significance because we will submit bears out the reasonableness of the counteroffer. The counteroffer comes in at 300 rand per tonne,
yes,
which is about 140 rand off what you were proposing should be paid.
Yes.
But in addition to that, it allows this tender process to be conducted,
yeah,
so that post-2018, ESKOM can ensure that it's tested the market, that it
yes,
sees what price it could get there,
yeah,
and all that Optimum retains is an option to meet the price.
So then it would absolutely...
So it absolutely protected ESKOM, we
yeah,
submit,
and
in relation to testing the market.
Yes. So, I mean, with not having looked at the letter recently, based on what you've conveyed, Ms. Hofmeyer, I would say it's a no-brainer. We should have accepted that.
Thank you. Chair, those are the aspects in relation to Optimum that we wanted to traverse with Mr. Bester, unless there's anything else.
No. Are you otherwise done?
I am otherwise done, and I will hand over to Mr. Maleka for the next witness.
Okay, all right. And we can excuse Mr. Bester now?
Indeed.
Okay.
Thank you,
Mr.
Chair.
Bester, thank you very much for coming to give evidence. You are excused, and if a need arises for the Commission to ask you to come back, you will be contacted.
Thank you, Chair.
Thank you. Mr. Maleka?
Chair, see, it's 11. I wonder whether we could not take an earlier tea adjournment and resume earlier than normal.
The tea might not be ready.
Okay. Well, let's use the Commission's resources.
Let's try and use the time that we have.
Chair, there are some housekeeping matters that I'd like to bring to your attention and seek your direction. By now, we are running a bit late in terms of the witness scheduled.
Yes.
There are 3 witnesses who are here present, whose evidence we need to deal with.
Yeah.
It is unlikely that we'll deal with all 3 of them today. Subject to your direction, we have arranged with the last of the 3 to be excused and returned tomorrow.
Okay.
And that is Dr. Ramoncha.
Yes.
So if it suits the chair, we'll ask him to go and do other better things in his life.
Yes.
And come back tomorrow.
No, that's in order.
Yes.
That's in order.
That leaves 2 remaining witnesses. The first is Mr. Sinton.
Yes.
He is here and he will be able to testify. The second is Mr. Pierce Marsden,
Yes.
supported by his colleague, who at the time was the co-business rescue practitioner for Optimum Code.
Yes.
He comes all the way from Canada in order to assist the Commission.
Yes.
And he has constraints of time. He would like to complete his evidence by tomorrow so that he gets back to Canada.
Yes.
I am fairly confident that we should be able to complete his evidence tomorrow,
Yes.
subject to other more important intervening issues, Chair, around
Yes.
tomorrow.
Yes.
But we would ask you to allow his evidence to be completed immediately after Mr. Sinton completes his evidence.
Okay. No, what's your estimate of how long, Mr.
I'd like to complete Mr. Sinton by 3 o'clock this afternoon.
Yes.
And
Yeah.
his evidence is quite important,
Yes.
and it has attracted all manner of attention, some of which I'll bring to your attention before I start.
Yes. And and the other two witnesses are likely to take how long each, more or less?
Only one of them will testify, Chair. The other has made a confirmatory affidavit to confirm matters
Okay.
that are referenced
Okay.
to his participation in the BR
Yes.
process.
Yes.
So I estimate that if I were to start with Mr. Pierce Marsden today
Yeah.
at around 3:30,
Yes.
I should be able to conclude this evidence tomorrow by tea time.
Okay. Okay. No, that's fine. I think that's in order. Yeah, the witness that you thought maybe should be released for today and come back tomorrow is released and must come back tomorrow.
Thank you very much, Chair. I'll then indicate to my colleagues that they can tell Dr. Ramuncha that he's released for now.
Yeah. Okay.
Chair, before I start with Mr. Sinton, well, I see he's ready here.
Well, I think he must go to, he may as well go and sit there. He is not unfamiliar with that place. He has given evidence before.
You can give it to him. Chair, we propose to deal with Mr. Sinton's evidence through a set of documentation which was previously handed up to you.
Yes.
It is a file which is marked U10.
It is marked U.
U10. And you will see just below U10, it is marked IHS Sinton. Chair, if you don't have it readily available, we have an extra copy.
Well, I think the one I found should be the one. It's marked volume U10, and then it's written his initials and his surname.
Yes.
It's supposed to be exhibit what?
U10.
U10.
Yes.
Can I ask for the umpteenth time, will the legal team make sure it's written exhibit number?
Yes.
U10 and all the others, because when I look for them, that's what I look for.
Yes.
What the exhibit number is. I'm
Yes.
going to mark this one exhibit U10.
Yes.
That is on the spine. If they can just write that on the spine, it will make things easier for me.
Chair, I feel sabotaged because I have conveyed your requirements
Yes.
umpteenth time
Yeah.
to the staff.
Yeah.
And at some point,
You threatened something.
I threatened something which did not endear me.
Yeah.
But I really would take it back again to
Yes.
make sure that your requirements are met.
Yes, please. I mean, even among those that are here, apart from this one, I see another one that is marked volume 5, but it's on the spine, but it's not marked what exhibit number it is.
I believe that Reverend Stemela is here and he will intervene on my behalf.
Yeah. Okay, all right. Thank you.
What we have discovered as we read through the statement and annexures of Mr. Sinton's file, Exhibit U10, is that there was one document or page that was missing, and we asked him to bring it today. And the page is going to become important when we deal with his evidence concerning what he was told regarding the relationship between regiments on the one hand and McKinsey on the other. So he has given us that page, Chair, and I've taken the liberty of marking it as page 107 capital A, which will follow 107.
Okay.
And secondly, Chair, if you go to that file at page 143.
What page?
143.
Yes.
You will see that there is Exhibit C there.
Yes, 1043 I've got, yeah.
Chair, I have tried even with my magnified glasses to read that document. I failed. And I asked Mr. Sinton to see whether or not he cannot get an A3 size copy of that document. He has kindly done so, Chair.
Okay.
And I have marked it page 143, Exhibit C.
Yes.
And I would ask your permission to place both these documents in your file.
Yes, thank you very much.
And Chair, that document is going to become important as and when Mr. Sinton tracks and traces various transactions and money flow
Yes.
relating to accounts that he had some concerns with. So I would ask you to place Exhibit C, A3 size, next to Exhibit 3, A4 size.
Just hang on 1 second. Let me put these where they belong. Page 107A should come
Immediately before immediately after 107.
immediately after 107.
Yes, Chair, you'll see page 107 at the bottom is
Mark
internally
3.
paginated 3.
Yes,
And then if you go to the next page,
it's marked 5.
5, so there's page 4 missing.
Okay. Thank you.
And Chair, whilst you're there, can I ask you to make a note, if not highlighting, that section of 107A, the heading Regiment to ISA.
Yes, thank you.
We'll come back to it in due course.
Okay, thank you. Probably we can take the tea adjournment now, or are you?
Chair, can I complete the documentation before we
okay.
start? I think it will make it much easier and convenient.
Yes, okay.
Chair, we have given several notices to various persons who are or may be implicated by the evidence of Mr. Sinton. They all come down to about 19 at this stage. The list may
Yes.
grow or not.
Yes.
We have not yet disclosed or included the notices in your file
Yes.
in line with your previous
Yeah,
directions,
yeah,
but I have a
yeah.
copy here in case anything
Yes.
arises from the
Yeah.
notices.
Yeah, no, that's fine.
We have only received 2 responses. The one is from McKinsey. We have communicated their stance to you in chambers, and therefore nothing further tends from what they had indicated in that response.
Yeah,
I shall not deal with that response any further, except to say that the attorneys are present here,
yes.
and if there's anything that arises and they want to take up with Mr. Sinton, he is
Yes.
here.
Yeah,
We would simply ask them to comply with the rules to the extent possible.
yeah.
The next set of response, Chair, comes from Regiment.
Yes.
And I'm afraid here I have to give you a bundle of documents. Chair, can I ask for your registrar's permission to give you two sets of documents. The one is the response from Regiment and the Commission's reply thereto.
Yes.
The next is a copy of the Financial Intelligence Center Act, and I'll indicate to you where that legislation becomes important. But first thing first, can I take you through the response?
I'll tell you what, I think we must take the break.
Okay.
You can take me through when we resume.
Yes.
You see, if we break at exactly 15:15, it makes it easy to say we come back at
Yes.
30:30.
My apologies, Chair. My apologies.
If we break at 17 minutes past, it becomes a problem.
No, I have.
Because if I say 30:30, it's less than the time, and
I really
people
apologize.
who need some comfort break might. Okay, we'll take the tea break and resume at 25:02.
Thank you, Chair.
We adjourn. Yes, Mr. Malika.
Chair, thank you very much. Before the tea break, I had handed up to you correspondence.
Yes.
Chair, we bring to your attention the body of that correspondence just to keep you up to speed about where things are in relation to regiment.
Yes.
Unfortunately, our administration has arranged the correspondence in reverse order. I would ask you, Chair, to go to the last tagged document. I have taken the liberty of putting the post-it stickers. The last one you'll see, it's a notice under Rule 3.3 to
Yes.
regiment.
Yes.
In response to that notice, Chair, the attorneys of regiments wrote a letter to the Commission dated 9 March 2019. You will find it as the second last tagged document.
Yes.
All I wish to bring to your attention in that regard, Chair, is their confirmation in paragraph 2 of that letter that they received the notice. In paragraph 3, they indicate that they had previously made themselves available to cooperate with the Commission and make statement to the Commission, and that their position in that regard has not changed.
Yes.
And then, Chair, if you go to page 2, paragraph 8 of that letter, you will see that they record the following: we accordingly request that the publication and presentation of Mr. Sinton's evidence be postponed for 30 days so as to afford our client opportunity to make its application and the Commission to rule thereon, and to afford our client an opportunity to consult with counsel and prepare for cross-examination. Of course, the Commission, via the legal team, responded to that letter, and the response is dated 11 March 2019. It is the document which is tagged in the middle of that bundle, and the sum total of the Commission's response via Mr. Pedler was that we don't accept that the evidence of Mr. Sinton be postponed. And what followed thereafter, Chair, is the document which is the first bundle, which is the first in the bundle. It is dated 12 March 2019. Sorry, is the one before 12 March 2019. The letter from the same attorneys of regiment. And you'll see, Chair, in paragraph 2, they accept that the Commission had informed them that they are entitled to make an application for
which one now? Not the last one, not the top one.
The
second top?
The second top.
Okay.
Where they confirm what the Commission told them. But of importance, Chair, is paragraph 3, where they say, we appreciate the need to do so, and our letter was not meant to circumvent due process, but rather to afford our client the opportunity to prepare the requisite application. And in paragraph 4, they note that Mr. Sinton's evidence will proceed today.
I'm sorry, Mr. Malaka. Let's start again. You have 4 dividers here.
Yes.
If you start from the top one,
yes.
Which one are you on right now?
The second one. The first.
Okay, is that the letter from the Commission to Smith Sugulam Incorporated?
No, the letter from Smith Sugulam Incorporated attorneys, dated 12 March 2019.
Well, I see one dated 9 March.
That we have dealt with. It was a request for postponement for 30 days. From the top, Chair, you could page 2 pages.
Oh, okay. Okay, I found it. Thank you. Yes, you were referring to paragraph 3 of the letter.
Yes. You will see there that the request for postponement was not meant to circumvent due process, but to afford the client an opportunity to prepare for the applications which it may be advised to make in terms of the rules. And if you go to page 2 on paragraph 5, you'll see the requested confirmation of when Mr. Sinton's evidence will be presented.
Yes.
And then the Commission did inform them about those requests.
Yes.
In terms of the letter of 12 March 2019, where they were told that Mr. Sinton's evidence would proceed, and they are entitled to get the statement and a transcript of his evidence after he testified. Chair, we have brought your attention to these matters simply to show that there's no basis to postpone Mr. Sinton's evidence.
Yes.
And we would therefore, with your leave, proceed to present that evidence before you.
Yeah, that's in order.
The next issue, Chair, is I have presented a copy of the Financial Intelligence Center Act, 38 of 2001 before you. And I'd like to take you to some of the provisions and explain why it is important. Chair, the first is page 18 of that bundle, where you will find sections 20, capital A, 21, and 21, capital A.
Yes.
These provisions impose obligations on accountable institutions and other persons who conduct business, such as Standard Bank, to ensure, firstly in terms of section 20A, that they do not deal with fictitious persons. And in terms of 21, there is an obligation for them to ensure that they know who their clients are and they can verify their identity and also verify the sources of funds in the accounts opened by their clients. And they have to do so in terms of a risk management and compliance program. The Act provides for the elementary aspects of that compliance program in a section which I will get to you, Chair. It is, I think it is, it has escaped me now, but I'll get it to you, Chair. And then the next section that I'd like to bring to your attention, Chair, is section 21, capital B, on page 19, which impose additional obligations on the part of the accountable body to take additional due diligence matters relating to incorporated entities such as companies or unincorporated entities such as trusts and partnership. And the obvious need for that provision, Chair, is clear, that an entity that is required to report ought not to take a defense that it was dealing with a legal person and did not know who was behind that corporate veil. And Chair, we would therefore suggest that it was proper and right for Mr. Sinton to report the transactions around which he had suspicion and on which he's going to testify by reason, amongst others, of this provision. And then, Chair, the next provision is the obligation to report suspicious or unusual transactions. You will get that in section 29 on page 29 of the legislation. The obligation is wide, Chair. It includes, amongst others, in terms of section 29(1)(a), the obligation to report transaction around which you conclude or have a reasonable suspicion that funds in the account in your bank constitutes proceeds of unlawful activities. And then C, it's important because it's the one that Mr. Sinton appears to have relied on. That is the obligation to report money which may constitute money laundering or for the purposes of facilitating money laundering. And Chair, the next section, which is important, is the protection of confidential information, because all of these things, you report them to the Financial Intelligence Center, and you do so in terms of the various reports which are called STRs, Suspicious Transaction Reports. And I'll, in a moment, indicate to you why that is important. And as you report them, you do so confidentially to protect the identity and further details of the person on whom you report. And the center itself has the obligation to protect the confidentiality of that information. But the confidentiality and protection of the information concerned, it is not without exceptions. Section 41 provides for exceptions, and you'll find section 41 at page 37. And one of the exceptions, Chair, is in paragraph D of that section, where the information is sought for legal proceedings, including any proceedings before a judge in chambers. We would submit that that is broad enough to include proceedings such as the present, and it is for that reason that we, by way of subpoena, secured the presence of Mr. Sinton before you, and we called upon him not only to provide information by way of affidavit, but also to produce several suspicious transaction reports which Standard Bank may have filed in regard to those transactions that he had some suspicions on. He has done so, Chair, and has produced a bundle of STRs under a subpoena, but they have been produced and they have been addressed to you. We have not looked at them because we don't want to violate any confidentiality protection. We will only do so if you give us permission for us to look at them. For now, Chair, I merely want to report that the reports are here, and we would ask for your direction that we begin to look at them.
Well, I will need to apply my mind to them. Of course, a question that arises in relation to section 41D is whether proceedings such as these are legal proceedings.
Oh, yes, Chair.
Yes.
We submit that they are.
And it may well be that you are right that they are legal proceedings, but one might just need to reflect on that.
Yes.
In part, maybe because one might just need to reflect maybe on that, but the one approach would be to take the view that even though a commission is not a court of law, it's the function of a commission such as this is such as to place its proceedings within the ambit of that term.
Yes.
But it may well be that there may be an argument that its proceedings are not legal proceedings in a certain sense and are administrative proceedings.
Yes.
Or something along those lines.
Chair, you'll see that the Act does not define legal proceedings.
Yes.
There is no definition.
Yes.
And therefore, it will boil down to
Interpretation.
interpretation.
Yes.
But
yes,
on the
yes.
interpretation, we contend. The Commission is a product of the Commissions Act,
Yes.
which gives the Commission, and especially you, Chair,
Yes.
the power to subpoena persons
Yes.
by means of a subpoena properly issued under your direction.
Yes.
And a subpoena is a legal process,
Yes.
and that process has been issued to secure the presence of Mr. Sinton here.
Yes.
And we would therefore submit that the Commission processes such as these
Yes.
are legal proceedings within the broad definition or understanding of the term.
Yes. And the Commissions Act says something to the effect that the bringing of witnesses to appear before the Commission happens or is required to happen following the same process as is used in a high court.
Yes.
I think there is a provision to that effect.
Yes.
So that may support that submission.
Yes. And Chair, my colleagues, especially Ms. Hofmeyer, wants me to make another point
Yes.
in order to justify the production of these reports.
Yes.
May I ask you to go to section 41 again?
Section 1.
41
Yes.
on page 37.
Yes.
You will see that another exception is where a person acts within the scope of his or her powers and duties in terms of any legislation.
What paragraph of 41 is that?
41 paragraph A.
No person may disclose confidential information held by, obtained from the sender except within the scope of that person's powers and duties in terms of any legislation. No person may disclose confidential information held by, obtained from the center except within the scope of that person's powers and duties in terms of any legislation.
Yes.
Now, the no person in this case would be Mr.
Sinton.
Stenton. Yeah,
Yes.
Sinton. So it would have to be that that he makes the disclosure within the scope of his powers and duties in terms of any legislation, isn't it?
Yes. We make 2 points there, Chair.
Yeah.
That these reports were filed by him in terms of section 34 of PRECA, which is the Prevention and Combating of Corrupt Activities Act. And secondly, flowing from the duty he had under Section 34(1), he also has a duty to disclose the information before you via a subpoena, which you issued in terms of Section, I think it's 3 of the Commissions Act, read together with the rules and the regulations. So he had the duty. The moment that you say, under that legislation, I call upon you to produce the information. And to that extent, the confidentiality provided for in the general provisions of Section 41 would be overridden by reason of that exception. In other words, once you issue a subpoena and you issue it in terms of the Commissions Act, he has a duty to comply with that legislation and the process issued under that legislation.
You see, my inclination right now is that this might be something that one needs more time to reflect on than just to deal with it in this fashion. And that it would be good to get something in writing that deals with the issues properly.
Yes.
Now, it may be that to the extent that I may be required to, you may be needing my order or directive to see the information that is confidential there. It may be that I need an application that sets out the background and everything, and some of the points that you have made, and makes reference to the legislation to say such a directive or order may be made because of A, B, C, D, E.
Yes.
Then I can look at that properly and then take an informed decision.
Yes.
So that's my inclination. I don't know what you have.
Chair, that's fine. We're grateful for that suggestion. We will then not refer to the contents of the STRs, but they need to be in safekeeping for the time being. And the best we know is your office. Can I ask your permission to leave these documentation in the safe hands of your registrar? And they may be retrieved.
The envelope is sealed, I assume.
Chair, I think
it needs to be properly.
Yes. We will ask for the commission staff to make sure that it is sealed before it is handed out.
I would rather you keep it and you make sure that it's properly sealed, because on its way from you to wherever, before it comes back, there may be a risk of it being disclosed.
Okay.
Or you can give it to
I believe that
Ms. Hofmeyer.
Ms. Hofmeyer has...
And if it is sealed in front of us, it would be all the better.
Yes. Okay. She has a double pair of safe hands than me. Chair, then that paves the way to the presentation of Mr. Sinton's evidence, because that is not affected by the niceties of the debate we've just had. May I then ask for your registrar to administer the prescribed oath?
Yes, do that, registrar.
Please state your full names for the record.
Ian Hamish Scott Sinton.
Do you have any objections to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you give will be the truth, nothing but the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Mr. Sinton, good morning and welcome once again. You are no stranger to the proceedings of the Commission, correct?
Correct, Mr. Malek.
Yes. You have previously testified in relation to paragraph 1.7 of the Commission's terms of reference, and your evidence is on record, but you appear here for the second time as a result of the subpoena which the Commission served on Standard Bank, correct?
That is correct.
Yes. And in response to that subpoena, you have produced a statement which comprises not only the body of the statement itself, but also several annexes attached to it.
That is correct.
Can I make sure that you are aware of what statement we will be dealing with and make sure that it is your statement? Before you, there is a bundle of documents which has now been presented before the Chairperson as Exhibit U10. And I see that you're paging through that bundle.
Yes, I have it in front of me.
It is properly paginated from page 1 until the end. Can I take you to page 1?
Yes,
You recognize that document?
I do.
It is headed Witness Statement of Mr. Ian Sinton. It is your witness statement.
It is, yes.
Can you go to page 27 of that bundle?
I have it.
There's a signature there. Whose signature is it?
That's my signature.
Do you confirm that you appended that signature on that page?
Chair, yes, I'm willing to so confirm. I would like, if I may, just to correct an aspect of the submissions made by Advocate Maleka.
Yes.
He, as is clear, doesn't have no knowledge of the content of the sealed envelope which I brought with me.
Yes.
And I'd like to emphasize that I received personally a subpoena to give evidence to you about our dealings with a range of named companies considering a range of named accounts.
Yes.
And included in the subpoena was a request that I deliver up all suspicious transaction reports which may have been submitted in terms of the Financial Intelligence Center Act. Now, I must make it clear that as a bank, we are obliged to report to the Financial Intelligence Center on all suspicious transactions. That reporting is undertaken by a division in the bank that is dedicated to that role.
Yes.
And because of the prohibitions on disclosure of whether a report has been submitted or not, that division is, in our terms, behind an information barrier. I personally have no knowledge of any suspicious transaction reports.
Yes.
What I can attest to here is that quite independently of suspicious transactions that have been reported to the Financial Intelligence Center, we have ongoing surveillance of clients for suspicious transactions generally to make a decision as to whether we can continue to deal with them or not.
Yes.
And it's that function that I performed while at Standard Bank. And it is information that I feel is confidential in performing that function, in particular, reports submitted under Section 34 of the Prevention and Combating of Corrupt Activities Act. It's of interest to me in the sense that the Financial Intelligence Center Act says that any person who submits a report to the Financial Intelligence Center is immune from either civil or criminal proceedings flowing from the fact of making that report.
Yes.
PRECA, as we call it, the Prevention and Combating of Corrupt Activities Act, obliges any manager who has knowledge of corruption to report that to the Hawks.
Yes.
But there is no equivalent protection. So if those reports are submitted to the Hawks, it is possible that the person who makes that report can become exposed to criminal or civil proceedings.
Yes.
And it's for that reason that I have included in a separate affidavit information concerning those types of reports, which I think it would be hopefully inappropriate for me to talk about on national TV.
Yes.
I would prefer that to be a subject matter that comes to your attention. You may rule on it, And it's for your knowledge only at this stage.
Yes.
If that makes sense.
What you are talking about now, is it what is in the envelope that Mr. Malega sought to give to me?
That is correct, Judge. What's in my statement here is information which is wholly unrelated to suspicious transaction
Yes,
reports made to the
yes.
Financial Intelligence Center.
Yes.
Yes.
So the point you are making is that what is in your statement, you have no problem talking about it openly, but what is in that envelope is something that you would like to be dealt with differently.
On a confidential basis, yes.
On a confidential basis.
Yes, Chair.
Okay, well, Mr. Malega does hear that, I hear that. I think that the legal team will reflect on that in the context of what you have just said and the discussion I had with Mr. Malega a few minutes ago. And at a certain stage, they would indicate to you or your Standard Bank's lawyers how they propose it should be dealt with. And before I make any decision, probably Standard Bank's lawyers, it might be a good thing for Standard Bank lawyers to make some submissions as well as to how it should be handled. I just mentioned that. Would that be fine with you?
That's fine, Chair. Thank you.
Okay, thank you. Mr. Malega, is that fine?
Thank you, Chair. Yeah, I understand that. And that's the reason why, firstly, we did not open the reports. That's also the reason why we thought we should get the guidance of the chairperson. But, Mr. Sinton, if I can give you the assurance that at the right time, and once we get the direction of the chairperson, we would be able to authenticate the reports we have received from you from the Financial Intelligence Center itself, because the Commission has been designated as an investigative body for purposes of cooperation with the Financial Intelligence Center. And to the extent that the information which you have made available to the Commission requires further verification, we will do so with the Financial Intelligence Center through the cooperative relationship it has with the Commission.
Thank you.
Yes. Chair, we'll get to that issue after we have addressed you on the legal niceties.
Yes, thank you.
But you are comfortable to testify today based on your statement, openly and before national TV?
Yes, I am.
Okay. Can I make sure that as you testify based on your statement, you accept that you have read it before you took the witness stand, correct?
Correct.
Is there any aspect of the statement you'd like to reflect upon with a view to modify it, alter it, or in any way change its context?
No.
Okay. You confirm that that statement is true to the best of your knowledge and ability?
I do.
Yes. Mr. Sinton, I'm going to confirm quite quickly background matters without repeating the contents of your statement, given the time constraints we have. Can I ask you to go to page 1 of Exhibit U10?
I have it.
You indicate there that up until last year, June, you had been the General Group Counsel of Standard Bank Group Limited, including its subsidiary, Standard Bank of South Africa Limited, correct?
Correct.
And you say that from June 2018 you stepped down, but you are still with Standard Bank.
That is correct.
Yes. What do you do?
I remain within the legal division of Standard Bank, managing its engagements with specific issues such as this commission and other litigation.
Yes. And you have an interest in matters that are presently being investigated by the Commission, correct?
Correct.
And you cooperate with the Commission from time to time.
Correct.
It is in that context that, as a result of the subpoena, you responded cooperatively to present your evidence today.
That is correct.
Yes. Mr. Sinton, if you go to page 2, In paragraph 2, you confirm that you received a subpoena from the Commission identifying various entities who held accounts with Standard Bank in which there was a movement of cash relating to those entities, correct?
That is correct.
Yes. And you confirm that after receiving that subpoena, you did your own investigation relating to those entities and movement of cash in the accounts held by them with Standard Bank.
That is correct.
I'm not suggesting that you yourself did the exercise. You did so with the help of your colleagues. Is that fair?
Correct. That is correct, yes.
Now, you say that you have previously testified before the Commission with reference to paragraph 1.7 of the terms of reference. You say so in paragraph 3 of your statement, and you explain the risk management policy of Standard Bank relating to the accounts held by its clients with it from paragraph 6. Do you see that?
Yes, I do.
And as I understand your evidence, that risk management exercise has two components to it. The one is statutory obligations imposed upon Standard Bank, correct?
That is correct.
Can you just give us the highlights of those statutory obligations?
There are many, obviously, but in the context of the business of this commission,
The major ones.
the major ones are the
Yes.
Financial Intelligence Center Act, the Prevention of Organized Crime Act, and the Prevention and Combating of Corrupt Activities Act. All the acts prohibit certain conduct, and all the acts impose severe penalties for non-compliance. From the Financial Intelligence Center Act point of view, the prohibition most relevant to us on an ongoing basis is the prohibition on entering into transactions that are suspicious and have not been reported to the Financial Intelligence Center. That of itself is a crime. Under the Prevention of Organized Crime Act, the various provisions, but the one that matters most to us is the prohibition on dealing in the proceeds of crime, effectively money laundering. And then the third is the Prevention and Combating of Corrupt Activities Act, which prohibits us as a bank from in any way knowingly facilitating corrupt activities. Judge, it's important to appreciate that in all three of those statutes, the offense is knowingly doing the prohibited act, but importantly, knowingly is defined as actual knowledge that what is being done is a prohibited act, but there's also deemed knowledge, i.e., what would a reasonable person, it's an objective test, what would a reasonable person in the circumstances ought such a person to suspect, and has that person with that suspicion done enough to satisfy him or herself that proceeding is not committing the offense itself. So it's not good enough to say, well, we had no knowledge of wrongdoing. We have to be worried about where there are suspicions of wrongdoing. Have we investigated the facts to determine whether or not the wrongdoing is occurring before we can proceed with any transaction? So based upon this policy, we monitor all of our clients' activities on an ongoing basis, and where we have reason to believe, quite apart from what is reported on the Financial Intelligence Center, where conduct appears to us to be suspicious, we will investigate, and if we think that the conduct is such as will expose us to contravention of any of these acts, we typically prefer to terminate the relationship rather than face the risk of prosecution ourselves.
Yes. Mr. Sinton, the second leg of that risk management policy and process your bank pursues is based on something less than a statutory obligation to report, which in your affidavit you call a reputational risk.
Correct.
From your testimony that you gave previously, you peg or base reputational risk on a private law relationship between a bank and a client.
That is correct.
Yes. Can you just take us through the highlights of why Standard Bank would, at some point, as part of its risk management policy, apply a reputational risk test to determine whether or not it should hold, continue, or terminate accounts of its clients?
Chair, yes, we obviously, as a bank, we have various stakeholders who are very concerned with the reputation we have for integrity and honesty. Clearly, many of our, not many, most of our customers, I would say probably all of our customers, are concerned to be dealing with a bank that does not knowingly expose itself to wrongdoing. We obviously are a regulated entity. We're highly regulated. We have ongoing oversight from the regulators both here and internationally. They're very concerned to know that we do not knowingly engage in activities which would be considered to be wrongdoing. We clearly have shareholders who invest in our bank and expect us, management, to behave in a way which is beyond reproach. And we also have employees who insist that if they work for us, they'd like to know they're working for a business that has a reputation for integrity and ethics. And all these considerations put together really give rise to the idea that if we find ourselves dealing with counterparties generally, it's not only just customers. Some of the people who supply us are also in the same category. Some of the people to whom we supply services are in the same category. Where we think we are being exposed to dealings which are considered illegal or immoral, unethical, we reserve the right contractually, in terms of the common law, to terminate those dealings. And that is because we think that we are exposed to reputational risk which we regard to be unacceptable.
Thank you, Mr. Sinton. If I may take you back to the first leg of your risk management process and policy, you identified money laundering as one of the transactional activities that you would be required to report on. Now, for those of us who are not steeped in your industry, can I ask you to decode the meaning of the term? How does money laundering manifest itself practically?
The most typical format, Mr. Chair, where money is used or generated in the commission of a crime, the source of the money being crime is sought to be hidden, often through the banking system, i.e. it is paid through numerous accounts in different denominations, different multiples, in order to disguise its origin, and so that money being the price of crime will end up ostensibly being for a legitimate purpose like paying salaries and wages. And there are multiple transactions in between, and the banking system is enjoined by the statutes to be particularly alert to this and to report it when it sees it.
As I understand your explanation, it is an attempt to hide or conceal the original source of the money.
That is correct.
It is what I think one of the bankers described as using a banking system as a laundromat to wash dirty money.
That's a fair description, Mr.
Okay. Mr. Sinton, you begin to address the concerns you had relating to entities that you describe as Gupta-owned or Gupta-related entities or persons associated with the Gupta family from page 5 of your statement. Correct?
That's correct.
Can you just summarize, if you could, quickly, what gave rise to your concerns in that regard and how you dealt with those concerns?
In the second half of 2015, Chair, we obviously noticed the well-publicized reports concerning the, in terms of Commerciality. There was prior landing of an aircraft at an Air Force base a couple of years before, which was deemed suspicious, but didn't necessarily impact upon any banking relationship. But in 2015, Absa Bank announced that it had terminated all dealings with the Gupta family and the entities that it controlled. Obviously, they are subject to the same laws as us. They apply, in our view, the similar reputational standards. They would have had good cause to do that. That was concerning. That was followed soon thereafter by KPMG announcing that they were withdrawing all their audit services from those same entities, citing reputational risk. And then I think their sponsor for Oak Bay on the stock exchange similarly said they were withdrawing. Now, obviously, those are for us red flags. We considered that if other banks had information which they found concerning enough to warrant termination of relationships, we ought to investigate ourselves. So we then set about an analysis in our own records as to which entities we had dealings with which were linked in any way to the Gupta family. And that was done both using internal resources, and we also use external investigative resources to gather together information with which we could then make our own independent assessment of whether we could, to the extent that we may have these entities banking with us, continue with the relationship in the light of what other banks had done and other entities had done. Yes.
Mr. Sinton, you canvass what you did from paragraph 12 on page 5 of your statement, and it's essentially a repeat of the evidence you have previously given. I don't think that there's a need to repeat it unless you insist that it should be repeated.
No need to.
Yes. But you mention in paragraph 16 on page 7 the fact that Optimum Colliery was a customer of Standard Bank. We have received a lot of evidence about the relationship between Optimum Coal Pty Limited and Optimum Coal Holdings and Glencore AG, Glencore International AG. I take it that you are aware of those entities.
I am, yes.
Can I ask you which of those entities at that point in time held transactional accounts with Standard Bank?
Optimum Coal Mine itself had transactional accounts with Standard Bank. There was a trust, a rehabilitation trust set up by Glencore for Optimum Coal Mine that also had an account with Standard Bank. I can't tell you now whether Optimum Coal Holdings, the parent company, had an account with us, but I would be surprised they didn't, because generally we have banking relationships with the Glencore group. So I can't say precisely which entities, but certainly Optimum Coal Mine did.
Yes. You are aware that in terms of the mining legislation, those who conduct mining activities or own mines are required to provide some sort of funds or guarantee for the rehabilitation of the damage to the environment caused by the mining entities.
I'm aware of that, yes.
I think they call them the rehabilitation funds.
Correct.
Are you aware whether there were any rehabilitation funds which were created by or on behalf of Optimum Coal Mining or Optimum Coal Holdings or an entity called Kurfontein?
I'm aware the Optimum, I can't remember the correct name of it, but the Optimum Rehabilitation Trust was a trust set up to house the rehabilitation fund for the Optimum Coal Mine, and those funds were deposited with Standard Bank, and they were with Standard Bank at the time of the change in control.
Yes. And those accounts were held with Standard Bank by the trust?
The trust.
Yes. So the trust was your client?
Correct.
Yes. Now, in paragraph 16, you talk about what happened in relation to the change of ownership relating to Optimum Coal, correct?
Correct.
And then you take the development further from paragraph 17 on the same page. And there you talk about the involvement of persons who at the time, I suppose, were acting on behalf of the new owner of Optimum Coal, which was Tegeta.
Correct.
Yes. Can you just give us the highlights of what happened in relation to your engagements with those who represented the new owner at the time?
Shortly after the change in control of the Optimum coal mine was announced, we were contacted by representatives of Oak Bay, who were the ultimate owners, I think, or controllers of Tegeta, to ask whether we would continue to provide banking services to Optimum coal mine in the light of the change of control where they had acquired control, but also in light of our stated desire to terminate all dealings with them. And that was a consideration which we had to take into account. At the same time, we received an email from a Mrs. Ronika Raghavan of Oak Bay asking us to transfer the funds we were holding on behalf of the trust to Oak Bay, the 1.7 odd billion rand, I think it was. We refused to transfer the funds held for the trust because we said we required a directive from the trustees themselves, not from the new shareholders of the mine. And within a few days, the trustees were changed, and Oak Bay appointed new trustees to the trust, and the new trustees gave us instructions to transfer the funds to the Bank of Baroda. And we still resisted. We said we'd like, because the beneficiary of the trust was the Minister of Mineral Resources, we wanted his permission to transfer the funds to the Bank of Baroda, and that permission was forthcoming in the form of a letter that these funds could be transferred from us to the Bank of Baroda.
Yes.
As far as the mine was concerned, we decided that the new controlling shareholders were directly and indirectly the same entities with whom we had decided to terminate all dealings, so we gave notice that we could not continue to provide transactional services to Optimum coal mine as a result of the change in control.
So that was the end of your transactional relationship between you and Optimum coal mine?
That's correct, yes.
Do you know who then provided transactional activities to Optimum coal mine after you terminated your relationship with it?
No, I have no knowledge.
You have no knowledge, okay. You say that in the course of your discussions with the new owners or their representatives of Optimum Coal, you had occasion to peruse the share sale agreement that was executed between Optimum Coal or Optimum Coal Holdings with Tegeta and Oak Bay.
That is correct.
And you realize that it provided for several conditions, one of which was the release of a guarantee. Can you just give us some sense of what the share sale agreement provided in relation to that guarantee? Chair, we will deal with that issue in detail when Mr. Marsden takes the stand, but I think it's important from the perspective of Mr. Sinton to tell us what he noticed and what was so important about it.
Thank you.
Our understanding, Chair, is that Optimum Coal Holdings was the parent company of Optimum Coal Mine. Optimum Coal Holdings, in its capacity as the parent, had given a guarantee in favor of ESKOM for the due performance by Optimum Coal Mine of its obligations to ESKOM, that ESKOM had imposed a penalty of about 2.1 billion rand upon Optimum Coal Mine for allegedly defective coal delivered, and had then issued a summons out of a court for recovery of that amount from both the coal mine as the principal obligor and from Optimum Coal Holdings as the surety or guarantor. And we noticed that it was a condition precedent in this transaction that the buyer to Gupta procure that Optimum Coal Holdings and its parent companies and all employees of its parent companies be released from this claim against the guarantor and for a 2.1 billion rand claim. And we, out of interest, asked Mr. Nazim Hawa at a meeting we had with him, he represented the Oak Bay Group of Companies, what consideration had been given by Gupta to persuade ESKOM to effectively release Optimum Coal Holdings and its shareholders and employees, etc., from this 2.1 million claim. And he told us that there'd be no requirement other than that Gupta step into the shoes of the guarantor. There may well have been other compelling commercial reasons around that, but from our perspective as bankers, we thought that to be highly unusual, that if ESKOM genuinely believed they had a claim for 2.1 billion rand, that they would waive it to enable Gupta to acquire control of the mine. So we were not satisfied that that was an arm's length arrangement at the time.
Yes. Well, Mr. Sinton, you'll be interested to know that the chair has heard a lot about how the condition in this new agreement dealt with the question of the guarantee. There was the release of the guarantee then in existence that was provided by Optimum Coal Holdings on condition that Tegeta and Oak Bay put up a substitute guarantee. And that never happened. Are you aware of that fact?
I am aware only to the extent that at the time I spoke to Mr. Hauer, I asked whether the substitute guarantee had been provided. His words were not yet. Yet the transaction had been completed.
Yes. And the chair has had evidence about the implication of the failure to put up that substitute guarantee. Firstly, any liability arising from the 2.1 billion rand arbitration claim would be gone. But secondly, continuing obligations under the CSA were not secured by means of a guarantee. And to the extent that there were penalties for defective code, ESKOM was not secured by means of a guarantee. But anyway, can I get back to your statement? You deal with several meetings we had between yourself and some of your colleagues with representatives of Oak Bay from paragraph 19 on page 9. You have previously said a lot about this, and I'm not going to ask you to repeat what you said in that regard, unless you want to reflect on it and deal with it.
I have nothing to add at this stage.
Yes. I then would like to take you to the substance of this round of your evidence. You begin with it from paragraph 23 on page 11. Are you happy that we should go there?
I am.
The heading on that page before paragraph 23 is Regiments Capital, Pty Limited. Do you see that?
I do.
Can you just explain to us who Regiment is and what relationship, if any, it had with Standard Bank at the time?
Regiments Capital, Pty Limited, was at the time, from as early as about 2012, was a transactional accounts with Standard Bank. and had acquired a reputation as being an advisor of choice, a black-owned advisor of choice to many of the SOEs, and so we encountered it in various guises in the market as being an advisor to SOEs, but in this context, it had transactional accounts with Standard Bank.
How many accounts, to the best of your recollection?
I'm aware of only one.
Right. And in paragraph 23, you say that what was of concern to you regarding regiments and your relationship with it is a media article that appeared that you annex on page 77 of your statement. Correct?
That is correct, yes.
Can I ask you to look at page 77 and tell us what was of concern to you that impacted on your relationship with regiments? If necessary, you can read out portions of the article that you relied on to form the view you express in paragraph 23 of your statement.
It's not mentioned specifically in the statement, but there was a report commissioned by the chairman of Trillion, by Advocate Budlander SC, into Trillion's dealings at ESKOM, and that had been published, and that led to a lot of media attention being placed on ESKOM and ESKOM's reliance upon Trillion. At the time, McKinsey, which is mentioned in that report, was a supplier of services to Standard Bank, and therefore the whole adverse media reports caused us concern.
Can I ask you to pause there? You talk about McKinsey supplying services to Standard Bank.
Correct.
Can you elaborate a bit about what sort of services?
Consultancy services. They were advising the bank on strategy and adapting our processes for the new age, for technology and what have you. It was quite wide-scale services.
McKinsey is a management services global entity.
Correct.
Yes. So was it providing management consulting services to you?
To Standard Bank, yes.
And it would therefore have access to your management processes,
Correct.
part of which will include the obligation to report.
I would imagine so, yes. At page 77, there's a news report where it says, reads as follows: after a week of global consulting firm McKinsey trying to distance itself from the Guptas and questionable contracts at ESKOM, more details have emerged of kickbacks to Gupta-linked shelf companies. Amabungani is reporting on Monday how McKinsey and Regiments Capital scored a massive consulting tender at Transnet. But Regiment's internal records show half of the profits were siphoned off to so-called business development partners. In 2015, Transnet awarded a 375 million rand consulting project to Regiments Capital and McKinsey. Regiments Capital's director, Eric Wood, would later join Gupta associate Salam Essa to start Trillion. Regiment's internal documents reveals that it paid over half of its contract income to facilitators, including shelf companies linked to the Gupta family and their associates. Records show that over a 10-month period, it diverted 55% of its income from the deal to so-called business development partners. Company records reveal that these development partners have direct link to the Guptas. That was one such report that obviously caused concern on our part.
Of course, these are media reports.
Correct.
They may be true, they may not be true. But what did you do, you as Standard Bank, after you got to know about this media report relating to, firstly, your service provider being McKinsey, secondly, your client being Regiments?
We requested a meeting with senior management of McKinsey,
Who were they?
and the initial meeting was the head of risk, the senior people from the country, South African country office, and the head of risk from the UK. That was the initial meeting, and then was then escalated to Mr. Dominic Barton, I think is the global head for McKinsey, who he was at the time, and their global general counsel, Jean Molina, her name was. They were all flown to South Africa to meet with us, so we could express to them our concern about this adverse information as had emerged about their dealings at Transit and at ESKOM. The
Mr.
response
Sinton,
was to say,
I'm sorry to take you back, and I'm sorry to ask you to recall things that may have happened months, if not years ago. But I think it's important for us to get matters of detail. You seem to indicate that there was an initial and a follow-up meeting with McKinsey.
correct.
Are you able to tell us more or less the dates?
I can't tell you now, but I can certainly get the dates for you and tell you in due course.
It will be helpful if you could. In relation to the initial meeting, who attended that meeting on behalf of and representing Standard Bank?
Again, I'll have a record, but I certainly recall it was myself and the head of compliance for our corporate investment bank
And
within the meeting.
from the part of McKinsey?
It was a Mr. Levy who was introduced as the head of risk based in London, and then there were 2 or 3 partners from the Johannesburg office. Again, I can get their names for you. I don't know, can't recall offhand.
Can I just rattle 1 or 2 names and see whether
Yes.
they would ring a bell to you? Do you know Mr. Vikasega?
He was not at the meeting.
He was not at the meeting. Do you know Dr. Eric Weiss?
Yes, his name rings a bell.
Was he, to your recollection, at or not at the meeting?
I cannot say.
Do you know the name, I think it's Jungling,
The name rings a bell.
Lawrence Jungling?
I would hesitate to say he was at the meeting.
Do you know the name David Fine?
I know the name, but no, he wasn't at the meeting as far as I can
Okay.
recall.
So we would proceed on the basis that you can't recall the names of the representatives of McKinsey at the first meeting.
Apart from Mr. Levy, I
Yes.
certainly remember his name.
Okay.
yes.
You'll come back to us about the date.
I will, yes.
And were these discussions recorded or not in any form, to the best of your recollection?
The actual discussions themselves were not recorded, but the import of the discussion was that the adverse reports had taken McKinsey by surprise, McKinsey, the international firm, by surprise, that they had appointed both local and international lawyers to do a thorough investigation of the information to try and get to the truth of the matter, and that they would share that information with us in due course. There was subsequent correspondence between us and McKinsey where we reminded them of that promise a few times.
We'll
But
get back to the promise because it's one matter where I would like to get your evidence. That was the first meeting. We go to the follow-up meeting. Again, you'll come back to us with a date.
I will, yes.
And was it ever recorded, or was the endpoints of the meeting ever recorded?
There were exchanges of mails and correspondence around it, but there was no minute produced of the meeting that
Okay.
I'm aware of.
Subject to questions of confidentiality, are you able to and prepared to produce the exchange of correspondence for the benefit of the Commission?
Yes, I am.
Okay.
committee, it really consists of us asking if there's any news about their own investigations and them telling us that they could find no wrongdoing.
Yes. It seems to me from your evidence that you took this matter fairly seriously because you thought that it's a matter that ought to be dealt with and resolved as between you and your service provider.
Correct.
You mentioned that McKinsey undertook to come back to you on what they were doing with those media reports. Question is, did they ever come back to you?
They did eventually come back to say that they had done their own investigations and had found evidence of, choose my words carefully, reckless behavior, bad mistakes made, but no wrongdoing of the type that had been suggested in the media.
Yeah, these are generalities and commercial camouflage, not to tell the details. I mean, reckless behavior.
I'm just summarizing what they told us, yes.
Yeah. But did you ask them what did they mean by suggesting that they found reckless behavior or bad mistakes?
Yes, for example, one of the issues raised in the Budland report was a letter written by Mr. Vikas Sager to ESKOM authorizing that a substantial sum of money be paid to Trillion. And they described that letter as a bad mistake. I took issue with that description of that letter. And I don't recall ever receiving a response.
Was that the only indication of bad mistake or reckless behavior which came up in the course of your conversation with them?
Well, shortly after they commenced with their own investigations, we took a decision to terminate all dealings with McKinsey. And so I really had no reason to push hard after that for an explanation.
But before you terminated the relationship, all I wanted to establish really was, did they share with you any documentation, investigative reports of the outcome of investigations that they said they undertook?
No, we requested such information, but it was declined.
Do you know why it was declined? I mean, did you find out?
My understanding, based upon one conversation with one of the attorneys, is that the investigation reports were provided by lawyers under the cloak of legal privilege, and therefore they didn't want to waive that privilege.
All right. You say then you decided to terminate your relationship with McKinsey.
Correct.
When, more or less, did you do so?
It was shortly after the initial meeting when they undertook to do their own investigations. We said, well, pending your investigations, we would have no further dealings with you. When you come back with a exculpatory report, well, then perhaps we could resume, but until then, we can't deal with you.
Okay.
The date I can get, it was a formal meeting with formal conveyance of that, I can get that for you.
Yes. And I understand with these sorts of relationships, Mr. Sinton, there's a closure process that takes place. Correct? I mean, you don't terminate the relationship and parties walk away without finalizing.
As luck would have it at this time, McKinsey, when we terminated, had just completed a major piece of work for us, and we're about to commence a new round of work, and we said we terminate. We said we're not going to sign you up for the new round until this is all clarified.
All right. That completes the risk that you identified in relation to McKinsey. Unless you have further information to share with us in that connection, I'd like you to talk about the risk that you identified in relation to regiment and what you did in that regard. You begin to deal with that issue from paragraph 26 on page 12 of your statement.
Correct.
You mention two entities in that regard. Well, let me start first with the transactional account that you say you recall, Regiment had at Standard Bank. You identify it by number there. Again, I'd like to confirm with you that that is the only banking account you are aware of that Regiments had with Standard Bank.
Certainly that I'm aware of, yes. I can't say that there aren't others, but that was the one that was flagged for me as being one warranting a further investigation.
Yes. Chair, you would recall that Mr. Sinton, in his statement, annexes extracts of the bank accounts under that account number. They begin from page 80.
Yes.
I will get to them in some detail.
Okay.
I'm just mentioning them purely for orientation purposes.
Okay.
Mr. Sinton, in paragraph 26, you begin to mention two entities, Chivita, CHIVITA, Trading, Pty Limited, and Homix, Pty Limited.
That is correct.
Yes. Did any or all of those entities hold accounts with Standard Bank? To the best of your recollection?
Homix did, yes.
Homix did.
Yes.
Chivita?
No, I don't recall Chivita having an account with us.
All right. You say something about those entities, and I'd like you to reflect on what you say about them in paragraph 26 and tell us your concern in your own words relating to those entities.
Chair, in the light of the adverse media reports suggesting that Regiments Capital had been guilty of wrongdoing, especially at Transnet, I asked people who are responsible for managing accounts, not myself, to look through the accounts and to highlight, if they could, transactions which looked out of the ordinary. And they brought to me a printout of the statements, some of which are attached to my affidavit. And if you looked in the statements, you could see there were large transfers into the account. In other words, you could see day-to-day transactions, salaries and payments to SARS and some things that looked like rent payments, what have you. But from time to time, there would be a large amount coming in that seemingly came from Transnet. And then shortly thereafter, there were large amounts paid away. You could see that often the directors of regiments would each take an amount, typically about 2 million rand each, out of the funds deposited. And then there were big payments made initially to a company called Chivita Trading, and then later on to a company called Homix Pty Limited. And those, I thought, because it was my call at the time, needed to be explained. We had no idea what the source of the money was, the application was. Advocate Maleka did mention to you that we need as bankers to be on top of what those are.
Well, Chair, I'm going to go with some reasonable detail to the accounts that reflect movement of bank balances
Yes.
from page 80. If you could go there, Mr. Sinton. You will see that that is a bank statement dated 28 February 2014, covering the transactional period 1 February 2014 to 28 February 2014, so it's a period of a month. And it's statement number 31, correct?
Correct.
And you will see that the banking statement was provided through a pack of pages beginning from page 1 to page 17, correct? For the present purposes, you chose to give us page 9 of...
Yes, that is correct. I extracted this. These statements were attached to a letter which I wrote to Regiments.
Yes.
So
We'll
what
get
I
back to
did,
the letter.
I took the whole pack. I took out of the pack numbered 1 to 17 those which contained the transactions which I wanted explanations for, and only sent those to Regiments.
Yes. The point really is that, and let's be clear, all you did was to take the bank statements for February, which was in more than one page.
Correct.
But for the present purposes, for the purposes of the Commission, you merely extracted one page of consent to you. In other words, a page that reflected a transaction of consent to you.
Yes, if you go to the previous page, page 79,
Yes.
you will see in the 4th paragraph, I say to Regiments, I attach our statements for your account with us numbered 31, 32, 33, 34, 36, 37, 38, 40, and 41. So I only sent them certain of the pages from the composite February statement.
And that's understandable because they would have received the full statement.
They would have.
Yes. Now, page 9, which is of consent to you and which is on page 80, reflects an entity called Chivita. Do you see that?
I do.
And it reflects an amount as a debit on the account of Regiment, correct?
Correct.
And by debit on a statement, it means that money flew from Regiment's account to the account of Chivita.
Correct.
How much was it?
5,130,000 rand.
All right. We will get back to what you did once you picked up this debit entry on Regiment's account. Can we go to the next statement? Again, it is for the same period, 1 Feb to 28 Feb 2014. Again, it is part and parcel of Statement 31, but this is page 10 of that statement, correct?
Correct.
It reflects an amount under an entity called Group Serve. Do you see that?
I do.
From your investigations, who is Group Serve?
That is Transnet.
Transnet.
Correct.
And there is an amount which is not squarely fitted alongside debits. It covers both the debit and the credit columns. Do you see that?
I do.
When I do the mathematics here, it seems as if that amount was a credit because immediately after that entry, The balance, which is reflected on the last right-hand column of that statement, increases from 5.9 million to 11.65 million.
That is correct.
So in other words, it's money coming into the account of regiments.
Correct.
Yes. So the bank balance improves. What is a reasonable conclusion you draw from this?
Well, that was a payment made by Transnet to regiments in that amount.
Yes. Let's go to the next one, which is page 82. What I picked up there, again, it is part and parcel of statement 31, but this time is page 11 of it. Do you see that?
Correct.
I picked up an entry there of concern because it's a substantial amount of 15 million rand. It is described as an interbank credit transfer. Do you see that?
I do, yes.
And from the mathematics of it, it improves the balance from 10 million to 25 million. So it seems as if it's inflow funds.
That's correct.
Do you know who paid this money into the account of regiment?
No, I don't.
You don't?
No.
Have you not made any investigation in that regard?
We would have, but I don't know the answer now.
Okay. Won't you reflect on it, and if necessary, come back to us on
Yes,
it?
I will.
Yes. I'd like to complete two more before lunch. The next one is page 83. Page 12 of the same statement 31. Do you see that?
Correct.
And there are two names that appear which I'd like you to deal with. The first is under the name Mohammed Bobat, FSF 11 13.03. Do you see that?
I do.
What is that amount for?
It's 560 rand, I think. Oh, no, sorry. 177,515 rand.
Yes, that's how I read it.
That's a payment to Mohammed Bobat, yeah.
Do you know who is Mohammed Bobat?
I don't know who he is, but I have heard of him as being associated with Mr. Salam Essa and Julian.
The next payment is to Chivita. Do you see it?
I do.
How much was it?
1,385,100 rand.
When was it paid?
On the 27th of February.
And the mathematics show that there was a reduction in the bank balance, which suggests that this money had flown from regiment's account to that of Chivita.
Correct.
Yes. Chair, can I deal with the last one before the lunch adjournment?
Yeah.
We go to page 15 of the same statement, number 31. There are 5 huge debit amounts. The first is the one on, I think it's a second entry from the top, described as CAT's third-party payment. How much is the amount there?
5,171,765 rand.
Again, the bank balance decreases, and therefore there is a money flowing out of regiment's account to that third party. Correct? Do you know who's that third party?
It says here SARS.
SARS.
Yes.
Okay. The next amount is Group Serve, and it is in the order of 45.4 million rand. Do you see that?
That is correct.
Is it the same entity that you described as Transnet?
Correct. That's a Transnet payment.
The bank balance increases to 55 odd million rand.
Correct.
So money had flown in from Transnet into that account of regiments.
Correct.
And the last one is Chivita. How much is the amount there?
5,643,000 rand on the 28th of February. It's paid from this account to Chivita.
Yes, because the bank balance decreases there, correct?
Correct.
Yes. Chair, would this be a convenient stage to take the lunch adjournment?
Yes, thank you very much. We'll take the lunch adjournment and we'll resume at 2. We adjourn.
Thank you.
Rise.